Just a second.
Good afternoon, everybody. It is Friday, October 18th, 2024. This is a regular meeting of the Commissioners of the City of Rehoboth Beach. We are live at second floor City Hall Commissioners Room. I'd like to call this meeting to order at exactly 2 o'clock p.m. If you would please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I'll call roll call. Commissioner Suzanne Good.
Here.
Commissioner Don Preston.
Here.
Commissioner Ed Stranowski.
Here.
Commissioner Patrick Gossett.
Here.
Commissioner Bunky Markert.
Here.
Commissioner Craig Thier.
Here.
And Mayor Mills. We have a full complement of the mayor and commissioners, and therefore we have a quorum and are able to formally conduct business today. Thank you all for being here. I want to thank those that are watching virtually. I also want to thank everybody that's here in person today. And as you know, we invite input on certain topics. We do have a time constraint of 3 minutes and one time per topic. Allowing you up here. We do want to bring your attention to a citizen comment at the end of the agenda. That is for comments from you all that are off topic, that are not on the agenda. We also have a 3-minute time constraint for that citizen comment section. Want to call your attention to support documents. Those are documents that support our agenda items. When they are done sufficient time ahead of the meeting, we embed them in the agenda the best we can so that you can go to cityofrehoboth.com, look up the meeting date, look up and actually see or even print out the support documents, the same type of documents that we have. I think we were up to 227 pages this time for the support documents. I would like to take the mayor's prerogative and change the sequence of a couple items on the agenda today. For the first set of real business will be after the city solicitor's report. We will have old business A, B, and C. That's the authority limits of the Building and Licensing and the authority limits of the Planning Commission. So we're going to do that much earlier in the agenda. Also, a couple changes to the agenda are just merely sequencing things. When we get to 14D, we're going to pair that with 15A. In other words, we're going to cluster the two basement topics. There's an old basement and a new basement topic. We're going to cluster those together when we get there. Similarly, for trailers, item number 13, we're going to pair with item 15C. Both of those have to do with trailers. We're going to cluster those together. But the main change in sequence will be that old business A, B, and C will be done much earlier in the agenda. With that, we are going to start off the evening with presentation of proclamation recognizing Breast Cancer Awareness Month. Vice President Gossett's going to join me, and we have a guest tonight also. Thank you. Right here. What about there? It's my pleasure to introduce Meredith Rothstein. If the name Rothstein is familiar, it's because her husband Howard worked here for quite a while in the Building and Licensing office. So we're glad to have you here today, not just for this ceremony, but also because she's a breast cancer survivor. So that's great. She is representing the Delaware Breast Cancer Coalition. Thank you for being here, Meredith. With that, we have a proclamation we'd like to present to you and your coalition. It says, proclamation, Breast Cancer Awareness Month, October 2024. Whereas breast cancer is the most common type of cancer diagnosed in women, and in Delaware and the U.S., it is the second leading cause of death in women. And whereas about 1 in 8 U.S. women and 1 in 833 U.S. men will develop invasive breast cancer over the course of their lives. And whereas October is nationally recognized as Breast Cancer Awareness Month and aims to raise awareness and to educate about breast health and breast cancer, the month also recognizes the many survivors, those living with metastatic breast cancer, their supporters and loved ones, and honors those lives lost to the disease. And whereas Breast Cancer Awareness Month is an opportunity to unite the community and spread important messages of early detection, screening and prevention, and assistance to women and men before, during, and after a diagnosis to increase health equity, reduce the number of new diagnoses, to increase survivorship, and to improve everyone's quality of life. And whereas researchers, scientists, and numerous nonprofit organizations are dedicated to discovering the cure for breast cancer, during the month of October, we acknowledge the extraordinary commitment and effort invested in this cause. And whereas we recognize that over 2.5 million Americans are breast cancer survivors that give us hope to a better future. Now, therefore, we, Mayor Stan Mills and Board Vice President Patrick Gossett, do hereby proclaim October 2024 as Breast Cancer Awareness Month, and that is proclaimed this 18th day of October 2024. And it's signed by Mayor Mills and Vice President Patrick Gossett, and we're going to present this to Meredith. So hold that there for the political photo op.
I will, thank you.
I've got a little speech I want to interject in here before I lose my voice. There's something that I need to address before we continue. I am addressing a growing lack of respect dished out by only a few, but it's infectious and spreading. I want to air it in public because it too often occurs in public. I have been listening to or reading of belittling remarks, disparaging people, and including threatening comments directed to commissioners, management, city staff, and city attorneys. And it's growing in frequency and magnitude. Contributors to this troubling behavior include some of us up here, some are constituents, but the most troubling to me are those that come from individuals on our boards or commissions and aimed at staff, management, and our attorneys. It's got to stop. I have witnessed these remarks in person or in writing for quite some time now, and I have some guilt for listening to these remarks and not stopping the derogatory remarks. Our employees are a valuable resource, and I feel the need to be more protective of them. In the future, I will do my best to stem disparaging remarks, even if I have to clean house somehow. I'm truly sorry for the name calling, and I will be going around and offering my apologies to those I haven't already visited and those who are impacted by the ugliness thrown at them. Look, I recognize that we all love Rehoboth Beach. We all have our own perspective on the direction of the growth of the city, and sometimes our opinions differ. We need to accept that there may be some disagreement and then at least agree to avoid fighting and get along. These behaviors are hateful, hurtful, and unproductive. I'm cautioning those that have been contributing to these activities to chill and invite all of us to strive to get along better and watch our choice of words and treatment of others. Thank you. With that, we've got a lengthy agenda tonight. We're going to do our best to expedite everything. If we get super late, we might have to take a look and see if anything needs to be jettisoned. We work hard, the assistant city manager, the city manager, and myself as a team creating these agendas. So it's got three minds on this, not just one. With that, we'll move on to the next item of business, which is correspondence. Again, just like a support document, correspondence, when it is received at sufficient time in front of a meeting, is embedded in the agenda as long as it relates to the agenda items. And you can see in the agenda, if you don't have one, they're outside on a table in the hallway. The agenda has listed three pieces of correspondence there. With that, we'll move on to approval minutes, and I see that there are no minutes to approve today, so we'll get to that next time. With that, we have...
Mayor, have about the minutes that will be forthcoming. Just a remark about the forthcoming minutes that I guess will be available maybe at the next meeting. I just want to make sure the record gets corrected. There was a legal assertion made at the last meeting that my suggestion of putting a consultancy cap of $10,000 would require a charter change in Dover, and it was made. It was not made by a lawyer. And I am from having looked into this, I believe it is our purview to rein in spending when we think it's appropriate. So I believe the board could impose such a spending cap as I suggested. So I just like the record to reflect that the minutes should include there was an inaccuracy stated at the meeting about whether we could do that or not. Thank you.
Commissioner, we'll look at that, but understand the minutes will reflect what happened at that meeting. So we'll deal with your correction later. Continue on. Again, there are no minutes to approve. Next is on the agenda is the city manager's report.
Thank you, Mr. Mayor and Commissioners. So starting with Rehoboth Avenue. So as many of you know, you might feel like you have whiplash with the on-again, off-again nature of the paving project for Rehoboth Avenue, but DelDOT has notified us that it is back on and it's official. The milling and paving portion of Rehoboth Avenue will begin work on the milling and paving shortly after the Sea Witch Festival. To help minimize the impact on businesses, this work will continue to be done overnight from 6 p.m. to 6 a.m. Sunday evening through Friday mornings. As part of the median work that's currently being done on Rehoboth Avenue, we do have 2 new ADA compliant ramps that were installed in the second block. Unfortunately, they do narrow the sidewalk significantly. Many of you may have seen the barricades that we have there. We are meeting with the designers and the contractor next week to determine the best resolution on those. The city was hoping that this would create 4 new ADA van compliant spaces without losing parking spaces, but it doesn't look like that is going to be the ideal solution, so we are looking to change those. So far, we are getting a strong response to our strategic plan community survey, which is available now through November 5th on Reach Out Rehoboth. Thanks to all of those that have taken the survey so far. In addition to the survey, residents, business owners, and other stakeholders may participate in 1 or more of the 4 community listening sessions that we'll be holding the week of November 12th. The sessions will be held at varying times during the week, and so look for those times and locations at cityofrehoboth.com and on Reach Out Rehoboth. Sea Witch Road closures. I'm looking forward to my first Sea Witch Festival this next weekend. The festival is October 25th through 27th with the parade at 11 a.m. on Saturday, October 26th. Please keep in mind that Rehoboth Avenue will be closed to all traffic beginning at 2 a.m. Saturday morning, and it will reopen around 4 p.m. after the parade fencing has been removed. Additional road closures and parking restrictions are noted at the city's homepage at cityofrehoboth.com. Related to our beach patrol facility, the city hosted a time capsule ceremony at the beach patrol construction site this last week. A time capsule with memorabilia from the beach patrol was installed into the emerging building. Among the items included in the time capsule were a 1950s black and white uniform top, 1980s striped trunks, a whistle, 2021 Beach Patrol calendar log sheet from July 4th, various photos, keepsakes, and newspaper clippings. Progress on the Beach Patrol facility is becoming more visible as several concrete pours have recently been completed and block and interior walls continue to go up. Plumbers and electricians continue to be active at the site, and prep work for the second floor concrete pour is underway. The pour itself is tentatively scheduled for the end of November. EDIS Vice President J.D. Bartlett will make a presentation on the path to opening before the summer season at the November 4th Board of Commissioners workshop. And then some follow-up on questions from the last meeting. The city's contract with Blue Hen for curbside recycling services does expire in April of 2027, so we'll be looking to negotiate a new contract on that about a year prior to its expiration. And at this time, city staff does not see a need for mandatory water usage limitations. The aquifer levels are steady and continuing to be monitored often. Staff does believe that voluntary conservation and wise use of resources should always be encouraged, but it's not necessary at this time. Street aid expenditures this month included $11,402.10, and that was paid to Delmarva Power, and I'm here for any questions you may have.
Any questions?
Yeah.
Commissioner Thayer?
Yeah, thank you. Couple of questions. So, a couple of things. So one is, thank you for arranging for EDIS to come in and present to us on November 4th. I think it will be informative for all of us to understand what the path is going to be to get open by Memorial Day. So I appreciate that. Second thing is, I did want to thank you for the parking data. I know that was something that came up at the workshop meeting, so I appreciate you getting me that parking data. I did receive it, so I wanted to, one, acknowledge I received it, and two, thank you for getting that to me. And I think Evan is the one who sent it to me, so
Right.
I'm thanking Evan, but I'm thanking you as well. So great. The last thing is you know, I did look through Mr. Duke's BVA analysis that he sent to us on October 3rd. And I think, as you know, we're running a deficit. Where I guess we're 5-6 months into the year, and since the year continues to progress, there's no time like now to start focusing on that deficit and seeing what we can do to reduce the expenses to try and get ourselves back to even, not have a deficit. In an effort to do so, I think one of the things I'm going to do, which I am going to do, is I'm introducing a motion to direct you as the city manager to issue an RFP for city solicitor legal services. Do I have a second? Do I have a second?
It's not on the agenda, Craig.
I can introduce a motion, Stan.
I know I'm
Be
interested in
careful.
this, so I'm trying to
Be
be
careful.
careful here. It's
Yep.
for purposes of FOIA, any action needs to be noticed on the agenda. So we can certainly get that on a future agenda.
No, I can introduce a motion. If you want to debate with me the timing of me introducing this motion as it relates to when I can introduce it in this meeting, that's fine. But I have the right to introduce a motion. We just discussed, as far as agenda goes, we just received the city manager's report where we discussed expenses. And this motion is about a deficit and expenses and the commissioner's responsibility, their fiduciary responsibility to manage the taxpayers' money. And this is about making sure that the taxpayers are receiving or are paying a fair and competitive rate for legal services. This is not complicated. It's not controversial. In fact, it's pretty straightforward. So, in an effort to have efficient and effective government, I'd like to get a second, see if I can get a second on the motion now. Go to discussion.
Second.
Okay, so I have a second on the table. I'd like to move to discussion. Stan, go ahead.
I'd just like you to repeat the motion.
Okay. So I'm introducing a motion to direct the city manager to issue an RFP for city solicitor legal services. And this is this is under, I think as many of us know, Section 19 in the city charter. Discussion.
Any discussion? I will be voting no.
I would ask that, is there a time frame adopted to this or attached to this? It would seem to me that this is certainly budget discussion area, so I would hope that that information could be retained and presented to the commission prior to the initiation of the budget for next year.
So, I would throw out I'd ask Mr. Tedder, what's a reasonable time frame for you to develop and issue an RFP? 5 business days, 10 business days?
I definitely think around 45 days would be ideal. I'd like to
To develop it and send it out, or develop it and get the data back?
develop and send it out.
Okay. So when would we get the data back?
Of the submissions for
Correct.
the RFP,
Yep.
typically an RFP is about 30 days.
Okay. So I think what you're telling me is it would take us 75 days to get responses to an RFP, so a little over 3 months.
To be able to award the RFP to a successful submission.
So, but what about, so I'm going to ask the question a little bit differently, which is, so steps. How long do you issue the RFP, stated differently, until you send that RFP out? When would it be due? So again, you can just give number of days instead of days. And then when would we'd have to review it, and then we'd have to reward it. So step 1, how long for you to develop the RFP and issue it?
Again, I think the 45 days would allow us to do our due diligence on crafting an RFP and then being able to release it.
Okay. So to me, it seems like an inexorbitant amount of time, but 45 days is on the table. You'd want to give the, again, I want to say the people, but you'd want to allow 30 days for people to respond to that.
I think you could go with 2 weeks at the
Okay.
shortest.
All right, so we go with 2 weeks, so 45 days to get it out, 2 weeks. Okay, so that puts us at 65 days, so puts us about 2 months. All right, and then how quickly would we have to review those and make a decision? And, I'm sure we don't have to make a decision at all, but what would your thoughts be on once we receive those back, opening them, reviewing, making a decision?
I think we could have a staff recommendation, issuing the RFP, receiving RFP responses by the regular meeting in December.
Okay, so I think to respond to Commissioner Gossett, yeah, this basically lines us up for the budget discussions, which typically begin in January. So by December, we'll have a good feel for what we should be paying for legal services going forward. And again, Baird Bandalis, if you want to respond to the RFP, you're welcome to responding to the RFP.
And another question I have for you, would this just be for solicitor services as you stated, or do you want a more comprehensive look at all legal services of the city? Because we do have multiple attorneys working for the city. We have outside counsel in other areas. Would you like to look at on-staff attorneys versus contract? I think there's a lot of ideas where we could go, but
So
right.
as you know, there is, a lot of concern within the community about legal services. So I think we'd be remiss if we did not issue an RFP for all legal services. I think you bring up certainly an approach that I think we should have a discussion about. I'm not sure if after a discussion would be the best approach. I think we'd look for your guidance, but do we bring on in-house counsel rather than contracting? And maybe, I suspect there's always going to be some area of expertise that our in-house counsel would not be able to handle, so we may have to go out. So that's probably part of the analysis. But yeah, I think as part of, as we talk to this motion, as part of this motion, we should probably also ask you to go and do some analysis on bringing those services in-house. We should look at that as well. So what I think I'm hearing, right, to get back to this motion, right, the motion would be to instruct you, to direct you to create and issue an RFP for all legal services, okay? We would look for that RFP to be issued within 45 days. We'd look for the responses to the RFP to come back in 2 weeks after that 45 days. As part of this, we're also instructing you to do some analysis on bringing legal services in-house. So I've kind of restated the motion. Do I have a second on that new motion?
I'll accept the changes.
Mayor, if I may,
Commissioner Preston?
with all due respect to my new colleague, I believe the motion is out of order. I would respectfully ask that the motion be withdrawn until a future meeting agenda when it can be properly noticed that this action is on the table for consideration. And I would ask the city solicitor to please give us your advice on this now.
Absolutely, happy to do so. So, not speaking to the substance of the motion at all. Certainly, it's an action you can take, but I would not recommend taking a vote on a motion that is not properly noticed. So we can certainly get this on the future agenda if you'd like. And it's just legal advice, so you could certainly do whatever you please, but I would not recommend taking a vote on that item right now.
Okay. So to my fellow commissioner, Mr. Preston, I'm going to respectfully, in line with what Mayor Mills had emphasized just a few moments ago about respect, I'm going to, respectfully disagree with you that it's not out of order, right? And, this is just kind of the classic we agree to disagree, right? We're never going to agree on anything. And no, I will not withdraw the motion.
Fair enough. Mayor, then I would like to just point out that in commissioner training, we are advised on how agendas are put together, what's required to be put on the agenda in order for it to be actionable. And this is not under a section of the agenda where it is actionable. This is simply a report by the city manager to the Board of Commissioners, but it does not suggest to us or to the public that under this item of the agenda that action will be taken. That's the only reason that I'm suggesting that this be withdrawn. It has nothing to do with the substance of the matter.
So Commissioner Preston, thank you. So Mr. Mills, could you please let myself as well as everyone else here know when I received, the date of any commissioner training I received that Commissioner Preston is referring to?
Sorry, say that again.
Could you please let Mr. Preston, as well as myself and all the other commissioners, know the date that I received the commissioner training that Commissioner Preston is referring to? Because I have received 0 commissioner training.
That is correct.
I'm not sure about Commissioner Good, but I will speak for myself, and I appreciate you confirming that, but I have received 0 commissioner training.
I understand. And putting that aside, you are hearing tonight what the proper protocol is, and you seem to be ignoring it, Commissioner, respectfully.
And again, respectfully, I don't agree with your interpretation of the protocol. So, ball's in your court, Mayor.
Well, I will not call a motion on it if the Vice President wants to.
Well, we've been instructed by the city solicitor that a motion as such as this is permissible, correct?
permissible, but in this case, I would not recommend taking it at this specific date. You could certainly take it in the future, but you risk a FOIA violation at this point.
Fine, asking questions. But this could certainly be directed to the city manager to take this action, as opposed to a motion.
I do see a good path forward. If you'd like me to put on the next agenda an analysis of the legal services that we currently utilize and what, agendize it for action, that could be a good path forward. And then some of the background information would already be put together, and we could probably accelerate that timeline that I previously gave you.
So I think that's appropriate, get a jump start on it.
Yep, the timeline, including, the timeline you're referring to is the creation of the RFP, the
Correct.
issuance of, perfect.
Yes.
Okay, great.
But I'm sorry, was that-
Go ahead.
just, is that by the workshop you're considering? Next workshop?
Well, how much time do you need?
Yeah, I can definitely bring it to the workshop, but we typically don't take action on items at the workshop, so I just want to be clear. You could direct me at that point to issue an RFP.
And I think there's, in fairness to you and the work that you're going to have to do, I think there's two parts to this, right? Maybe even more, but one is the RFP. So I'd like to see that at the workshop for action. And then there's the analysis of bringing legal services in-house. And it's probably not fair to ask you to complete that analysis in 2 weeks. So giving you more time to do that, I think would be appropriate. I'm not sure if anyone else has any comments.
No, I think that's appropriate.
To confirm, if I may, though, for timeline here, the RFP, or draft RFP, could be prepared for review at the next workshop as an agenda item.
I think so. Yeah.
And accompanying that, would you be able to provide the existing data on our legal expenses to date for this fiscal year?
Definitely.
So perhaps that data could be used then to develop a conversation at the regular meeting about the need or financial expenses for in-house counsel. So a step process here to carry that through. So those two could be completed by the workshop for presentation with an agenda item at the workshop for a draft RFP for solicitation of outside services, legal services, and then also existing data on financial expenditures to date in this fiscal year. And if possible, I think it would be helpful to look at the last year also fiscal year.
Yeah, I think all of those could be accomplished.
So do we need the motions withdrawn, or they're invalid anyhow, or what?
Yeah, I mean, I'm willing to, if you need, Mayor, if you need, sure.
Formally withdraw, yeah.
Yeah, I withdraw my motion. Second,
Honky, are you okay with
is that okay?
Yeah.
All right.
Aye.
All right, so we've got direction without
Thank you.
having a motion. Thank you. With that, where are we here?
Still questions on the city manager's report?
City manager's report. Anything else?
Go ahead. Patrick, you had a question?
Just, is there any update on our development of the mixed-use task force?
So I think the mayor was actually planning to make an
Yeah, I was going to
announcement.
comment later, but we have 3 respondents so far that have applied. We also have 2 from the Planning Commission. I think it's Susan Stewart and Susan Gay. Is that correct? Correct. So we've got technically 5, but we haven't vetted the 3 yet, and I have no responses from anybody up here that's interested. So, yeah, so if anybody up here is interested, then please let me know.
Memory
So
serves
we're
me-
gonna need to extend the timeline, yeah.
But if memory serves me correctly, and I could be misremembering as I say, but there was extensive discussion on the use of a consultant for this, to manage this process, or doing it in-house. And I don't know if that was resolved, or we're waiting for a report back from our Director of Planning, or how we left that.
So that agenda item did include that use of the consultant.
Okay.
So when that motion carried, it was the plan as presented.
Okay, great. Just thank you for the confirmation.
Mayor?
Don, I think, was next. Commissioner Preston?
Taylor, you mentioned that the community engagement on the strategic planning survey has been strong so far. Could you just give a little bit more flavor to what that means? Just, against expectations.
Sure. So Lynn is actually keeping a tally. I think yesterday we were up to over a dozen responses.
I think we were at about 50 yesterday. So the survey went live on the 5th. We advertised it via social media, and in yesterday's Lines in the Sand, we have right about 100 responses
Oh, wow.
so far.
Great, thank you.
Anything
Thank you,
else,
Mayor.
Don?
No, not at this point.
Commissioner Good?
Just to refresh the public's memory, I was the lone nay vote, thinking that a $42,000 consultant was unnecessary. We have yet to show what the benefit of having a mixed-use ordinance is when we have only 288 commercial properties in this entire town. So we seem to be adopting large municipalities' strategies in dealing with a prevalent problem, whereas we have a very small-scale problem. So I think the lack of enthusiasm to join this task force, with the exception of 2 planning commissioners who have always apparently enjoyed close involvement with planning in the city, might be indicative that the public isn't convinced that there are benefits. And so I hope maybe during the discussion on October 7th, 2 of you, like myself, had hesitations that we needed Wallace Montgomery to be contracted for $42,000. So perhaps there could be some consideration now for making sure that our director of the planning department does make an attempt to run this task force in whatever form it may take without a consultant serving as a liaison. Thank you.
Taylor, I'm not sure if you were interrupted in detailing exactly what you recall was the motion. I thought the motion to go forward with the task force did not micromanage the city manager and whether or not they hired the consultant.
That's correct.
Your
It was
room.
a
So,
support.
so really, I'm sorry.
5 to 1 to support, yes.
So really, the question is, are you making any progress on hiring the consultant or executing the contract with the consultant so that we can reconvene the task force?
Right. We have the scope of work from the consultant, but I wanted to make sure that we assembled the task force before we executed that agreement.
All right, that answer your question?
Yes, thank you.
Commissioner? All right, thank you.
Mayor, I have
I'm
one
sorry,
last
Commissioner
question.
Stranowski?
Related to the road work on Rehoboth Avenue, glad to hear that DelDOT has brought the millwork portion of it back. The timing of that is from 6 p.m. to 6 a.m., whereas the current timing of the curbing is 9 p.m. to 6 a.m. My understanding is there's been some discussions with DelDOT to start as late as possible to not disrupt the dinner rush and businesses right at 6 p.m. Is that accurate, and is there any feedback from them on that?
That is correct. So we are working with them to try to make it later. Our public works director has been in constant contact with them, so I'll be able to provide you more information on that probably in the next week.
Okay.
We are meeting specifically with DelDOT out on site regarding the ADA ramps, so I will continue to ask.
Okay, appreciate it. Thank you.
Anybody else? Thank you very. Walter, did you have a comment? You're limited to 3 minutes, please. State your name and relationship to the city, please.
Walter Brittingham, 123 Hunlopin Avenue. I don't want any babble, I'm looking for the truth. But we have Rehoboth Avenue project is not big. but it's big enough, but it's not beautiful. And I can't speak for all the people in town. I can only speak for myself, but it's not going well. I asked at the past 2 meetings, got no answers. These are the bidding documents. I asked for plans, no answers from the front table, nobody. I think it's very interesting that both Public Works directors, the one we're continue to retain and the one that is, other one's not here, that there's nobody here to answer questions. I think that's very convenient, Mr. City Manager. These are the bidding documents other than the plans. And the last meeting, I asked, has anybody seen the plans? And the existing Public Works Director said finally that he had gotten a copy on email, but none had been made available to you. You have to decide whether that's offensive to you, that you need to know what's going on so you can answer questions to the community. But I just think it's out of place. I have a comment because Mrs. Diefendorfer had a good idea about extending the restroom, for Sea Witch at the north end of the boardwalk. And I tried to be nice and say, thank you all for coming up with a solution. But I asked how much they cost and what was going to happen. But when I went down there, I was really surprised to see that they were locked up and they weren't available. There were no signs down there that said that they're temporarily closed because there's a crane down there. Are they going to be open this weekend? Are they going to be open next weekend? And because they're extended, but how much did it cost? The First Street, Rehoboth, I haven't watched the clock, Mr. Mayor, but First Street has been having some curbing work done, and I think everybody needs to understand that possibly, I say possibly, you're going to have to address the parking on these streets if you're going to be moving the curbs in, because First Street has problems enough with parking without narrowing the street on both sides since they're adding curbing. And I bet none of you know that. I bet none of you know that. Shortly after that, the Rehoboth Avenue project is moving forward. That's just fine. The paving will take care of itself. But what the people went through and the people that got injured up at the browse about and stuff like that, I have personally told them, when you see somebody get hurt, call for the ambulance.
Thank you, Walter.
Get a report. Get a police report, because it's wrong otherwise. And then
Thank
I'd
you,
like
Walter.
to know, I have one final question. I'd like to know who authorized, I know who put signs up, probably Bill did, but who authorized the signs at the Admiral Motel for the oversized parking spaces? And why don't you report that and say why and how it's supposed to work? Because right in front of the Admiral Motel, there was 2 small signs in regular parking spaces that says oversized parking only.
Thank you, Walter. Tom,
Now, excuse me, when will we get answers to the questions?
I don't know.
I don't know. It sounds like all of you.
Identify yourself.
Tom Gaynor, property owner in Rehoboth. Suzanne, thanks so much for running up into the buzzsaw on the outside contractor issue, the outside consultant issue. And I'm grateful that you tried to correct the record from the legal opinion that was erroneously given by one of your fellow commissioners who's not a practicing lawyer, and who should identify his opinions in the future when it comes to legal assertions that are clearly erroneous. The other thing is, as I've asked for, I think, the last 2 meetings that I've been here, I'm not at all of these meetings, probably grateful, you're grateful, I'm grateful. When you give a manager report in any other context than any other business, the fundamental issue is the major projects, where are we against budget, where are we against the calendar, and where are the overages? You don't talk about money in any of your manager reports, and it's incredibly frustrating. The lifeguard station is an issue. It's a consistent issue. You're not giving us details with regard to the financial and the fiscal responsibility that's clearly, yours to manage. Commissioner Thier, good luck. It was a great attempt at stirring up the pot and trying to get some economic control of this organization. My unsolicited advice is You need 3 people to work with you. And if you guys would all astutely learn a little bit more political collaboration with Ed, Don, and Suzanne, you guys could actually alter the fundamental power dynamic, which is why people sent you and Commissioner Good here, which is to get control of the finances, get control of the competency, and get control of the execution strategy of this board. If you don't do that among the 4 of you and realign the power on this commission, you're going to continue to get pot-shotted and shut down. So I hope that the 4 of you start working together in a coherent fashion, which is why we sent you here. And to Commissioner Tarnowski and Commissioner Preston, this is why we sent them here, to help you. And please start functioning more coherently for the competency that you're trying to do. I appreciate it. Thanks.
Thank you, Tom. Identify yourself, Lisa.
Yep, Lisa Schlosser, 14 Dover Street. I wanted to follow up on something. I also commend Commissioner Thayer for jumping right in and making a proposal, and I thought the discussion was great. My question is this. I think we bypassed that question about training pretty quickly, and it seems to me, given the budget situation that we had over the past 6 months, where we had a deficit, we didn't have a deficit, we had to raise taxes, which we never heard back. Are we going to decrease taxes again now that we have this massive surplus? It clearly showed that even long-term commissioners didn't really understand the budget and the budget process, given the questions and all the inconsistencies that came out. So I would just encourage you to please set up some training for the commissioners, particularly since we have new commissioners, and include some information about budgeting, our budget, how to read the budget, how to ask the right questions about the budget, so we don't go into the kerfluffle that we had this year. So I just wanted to make that comment about training and putting some training in place for all the commissioners. Thank you.
Thank you, Lisa. With that, I don't even know where we are.
City Solicitor report.
Alex Burns, City Solicitor.
Thank you very much, Mayor. I don't have anything to report today. Thank you.
All right, thank you very much. With that, we'll move on. As I indicated, we will be moving up old business A, B, and C to this position. This topic has to do, there's an agenda item report, and there's also different proposals, proposed draft ordinances. Purpose of this item is to discuss the authority of the Planning Commission or the Building Inspector to interpret and enforce Chapter 270 zoning of the municipal code. Before I turn it over to our Board of Commissioners and Building and Licensing Attorney Consultant, Max Walton, I just want to state, if you recall, our last vote was 3-3. And just want to remind everybody that vote failed to establish a public hearing date. That's all we're trying to do. We're not trying to talk about the merits of it right at this point. Want to try to sound now, Max, I think you'll explain it a little better than me, but my hope for today is that we talk through this proposal, that we adopt a resolution establishing a public hearing on December 9th that includes both the proposals that you're going to hear about, a building and licensing version and a planning version. My goal is to get that on the agenda. And then I'd like to talk afterwards about a request by the Planning Commission to have a joint meeting between the Planning Commission and this Board of Commissioners. And if we talk about that and there's agreement, I would propose that would be mid-November, so that would be in between today and the public hearing date, and go forward. But anyhow, let me turn it over to Max Walton.
Thank you, Mayor. You got it exactly right. There was a resolution for a public hearing on the ordinance. That vote was 3-3 on September 20th. So it was back to the drawing board. What's before the commissioners today, at least to set a public hearing, are mirror image ordinances. One ordinance vests the authority to interpret the zoning code in the planning commission. The other set of ordinance vests that right in the building inspector, subject to appeal. As far as the ordinance that were introduced, or introduced is a tough word, there was a discussion about setting a public hearing on at September 20th. The ordinance that's before you is pretty much the same. There are some differences, so I want to emphasize, we had some discussion about the pending ordinance doctrine before. This ordinance that's taken out, it's prospective only, and you might ask, well, why are we here? So a dispute has arisen whereby the Planning Commission made some code interpretations. The building inspector had a different code interpretation, and the Board of Adjustment had a different sort of view on the subject. I want to emphasize, we cannot talk about that particular application because there is still an appeal pending to the Board of Commissioners where you have to act as a judge. But we can say that there is a dispute that's out there to be resolved if we can legislative. And the idea is hopefully to provide clarity with respect to that respect to that situation, and hopefully to avoid litigation about it going forward. So that's why we were trying to resolve this in a legislative manner. FOIA makes you guys do things in public, and that's why we're having, we're putting it up there, right? That's the best we can do. It's two different variations of exactly the same theme. I suppose that you could do nothing. You could not set a public hearing. You could not go forward. We would then remain with that dispute that exists with respect to that other project. I'd like to address, if it's okay, one of the sets of public comments that came in that I was able to read. The public comment said, in effect, there's no jurisdiction that requires the Planning Commission to appeal to the Board of Adjustment with respect to one of the sets of the ordinance. There's already a provision within Delaware Code, 22 Delaware Code 324, and it says, appeals to the Board of Adjustment may be taken by any person aggrieved or by any officer, department, board, or bureau of the municipality affected by any decision of the administrative officer. So as it sits here today, if the building inspector made a determination, the Planning Commission or other board or commission could take an appeal to the Board of Adjustment. So that's already in the law. So why is the ordinance written the way it is? Well, the Planning Commission, because they can take that happen, usually there's a deadline for filing an appeal from the building inspector's determination, e.g. 30 days. That's the general sort of standard. If the building inspector made a determination very, very early in the process, and it took the Planning Commission another year before it came before them, they would never have an opportunity to appeal. And functionally, there would be a bar because this time for appeal had run. So the actual ordinance that's before you is to make sure that if you guys went the building inspector route and the Planning Commission disagreed with the decision of the building inspector, that they would not have forfeited their right to appeal the way it's written now. We're trying to build in some safeguards that trying to say that things aren't time barred based upon the action. So that's the reason for it. But I want to be very clear. I do not have a fighter in this fight. I'm asking you guys to pick a lane or take all of them to public hearing and let the public process play out. That's ultimately your decision. I believe that you can vest that authority in the Planning Commission, and I also believe you can vest that authority in the building inspector. And I answered some questions before. Many times it is the building inspector, but I do believe that you would have the authority. And I do also believe that the code is unclear as it stands. It's ambiguous, and that's why we have the dispute that we have, which we can't talk about. So if you do decide to adopt one resolution for a public hearing or the other, that's fine. If you decide to do them both, you have to vote on and set two different resolutions need to pass. And if you do two different resolutions, that's okay. I'm not asking anyone to pick today. Mr. Mayor, do you have any questions, or does any member of the commission have questions?
No, I just want commissioners to know that today we've got a three-minute time limit on conversation, including planning commission members. But if we go to public hearing, I would consider planning commission a party and have, I don't want to say unlimited amount of time, but be equals with us, so to speak, and have more time, not be limited to the 3 minutes. And then, if you recall, I mentioned at the beginning, there was a request for a joint meeting between the Planning Commission and the Board of Commissioners. And that I would propose that if we want to go that route, I think that could be beneficial, that that would be the middle of November. And I would also consider them equals time-wise for that, so that they have plenty of time to be able to give their position and their perspective, et cetera. So again, my hope would be that we make an motion and adopt it, setting a public hearing for December 9th, 9 a.m. For both the building inspector's version and the planning commission venue. Why both? Because we need to, if the public hearing was focused around one and we went in there and voted against it, then we don't have an alternative. And I'd rather have both versions in the motion so that we can entertain comments from the public, the planning commission, and the commissioners on both versions, and then hopefully at that public hearing be able to conclude conversation with a vote on one or the other.
Mayor, if I may, Mr. Walton, just for clarification, if I could, when you're opening, talking about the appeal process that you read from the code, does that indicate or translate that the Planning Commission or any thereof would have standing in a court of law?
Yes, there's the famous case, Newcastle County Department of Land Use versus Newcastle County Board of Adjustment.
Okay.
Yeah, I mean, it's written pretty broadly because there's an element of being aggrieved by the decision, but obviously I think they would be able to satisfy that in most instances because they're reviewing the plan that's going to be appealed.
So it is not clear, but is based on previous case law that a planning commission would have standing in this type of statement.
It doesn't happen often, but let me just read you the language, right? Appeals of the Board of Adjustment may be taken by any person aggrieved, okay? Person aggrieved, or by any officer, department, board, or bureau of the municipality affected by any decision. So the person aggrieved language is a person aggrieved, but that or statement says you can take an appeal from any officer, department, board, or bureau. So I believe they would have standing, yes. And it has happened in the past, it just doesn't happen often.
Nitpicking here, the term commission is not mentioned in that.
That's correct, and I don't think that anyone could read that statement and conclude that it's not a board.
Okay. Thank you very much for your comment.
Anybody else? Sure. Commissioner Thayer?
Really one question. So, if there was a change, right? From these-
Microphone.
Sorry. My question is, and the term I'm going to use is retroactivity, right? So we currently have Bellhaven, and again, I'm thinking what's in process in front of Planning Commission. So we have Bellhaven, we have one Rehoboth, there may be some others as well. So from a retroactivity standpoint, it was my understanding from what you had said previously is that it doesn't apply retroactive. So anything that's kind of in the system stays in the system under the current, I think you understand where I'm going.
So the ordinance as written, and that's a legislative determination whether or not you want to have it, the ordinance as proposed, it's effective upon adoption. It doesn't apply retroactively, because sometimes we write it and says, we meant to do this a year ago, and it can go back that far to applications that were submitted. So it's when the ordinance is adopted, it affects whatever project is out there. You could certainly, as part of going through your legislative process, take that statement and essentially grandfather anybody who's not in the process. But it would be effective, once it's adopted, it's effective upon adoption.
So anything, just to be clear, and, you know, you can tell me to stop talking anytime, just to be clear, if it gets passed, the date comes, anything that's in the system, regardless of where it's in the system, is under the new ordinance.
That's correct, provided that there are other doctrines, and maybe we could have a chat about this, but there are other doctrines. And for those who were here for the Ocean Baymark case, that ordinance was effective upon adoption, and they claimed that they had a vested right. In other words, they have those additional doctrines that apply. But the way it's written right now, and you guys can change it, is it's effective upon adoption. So the day it's adopted, it applies.
Okay, all right, great, thank you.
Anybody else?
Mayor,
Commissioner Good?
a question for Mr. Walton. I'm a little frightened by the prospect that the Planning Commission would have standing. Does that mean that this, no matter what, if it were even some whimsical and capricious reason that they decided they didn't like the architecture or of whatever it happened to be, would the city be obligated to pay the legal fees with no real controls over you know, how long, how protracted it would become with this Planning Commission appeal? Thank you.
That's a budgetary concern that I'll let you all figure out.
Anybody else?
I have a couple of maybe comments and a question in no particular order. You mentioned the possibility of a joint meeting of the Board of Commissioners and the Planning Commission. Simple question is, since this appears to be not just a discussion between the Planning Commission and the Board of Commissioners, but a three-party discussion with Building and Licensing and the Planning Commission and the Board of Commissioners, would Building and Licensing have representation that's equal to the rest? As you suggested, the Planning Commission would have equal standing with the Board of Commissioners.
Well, Max would be attending on our behalf and Building and Licensing's behalf.
Okay.
Nope.
No?
Nope. I represent the commissioners, and I do not represent in this case. The board, I've represented them in the past and other things, but not in this one.
Half right. You represent us.
You.
Right.
So I thought that might be the case, and that's what prompted the question really is, I would suggest then, if we were to go this route of a joint meeting, that we would also invite Building and Licensing to sit equally at the table, because this is not just a discussion between us and the Planning Commission. Just a suggestion. And then are you looking for comments now on feedback that we've gotten, or would you rather take that at another point in the meeting? It's up to you.
Whenever you feel it's appropriate, at some point we want to go to members of the public, but.
And you'll come back to
but
us?
There's maybe two discussion points. One is whether or not we want to hold a joint meeting. There's some that may think that why invest time in a joint meeting if they're going to be at the table for the public hearing. And so that one would be whether we agree to go to a joint meeting or, I'm sorry, the second one is setting the public hearing on December 9th for one or two ordinances. So you want to go ahead?
No, I'll hold them for another point. It's fine.
Anybody else? So I guess I look at this conversation right now, going to the members of the public, as more so the merits of being ready and going to public hearing versus the merits of the ordinances themselves. The merits of the ordinances, to me, are reserved for the public hearing to be debated. So would anybody like to speak? Remember, we got 3-minute time limit. We got Mike, Earl, and Richard. Your name and
I'm Mike Strange, 4 Stokely. I'm here speaking
Keep
as
an eye
a,
on the clock, please.
here speaking as a citizen, not as a member of the Planning Commission, but that kind of gets inextricably tied together. I think all of you have a report that I wrote as an individual. I would point out I spent about 45 hours on that, and you got all of that intellectual capacity at zero cost, addressing Ms. Good's concern. Had I done this in 1998 when I was consulting, it would have cost you $400 an hour. So you didn't have to lay out $18,000. Now it would have been a lot more now. The point is, with regard to the comment that was made by the attorney, that the law in Delaware says you might be able to do what you want to do. But when I did a statistical analysis, and I can only say it with 90% confidence, there are 36,000 municipalities in the United States, and none of them do it the way that is proposed. There must be a reason. And there are a few municipalities, which I found very interesting, and I was very surprised, where the Board of Adjustment is the Planning Commission. They are one and the same. I'm not recommending that, but I'm just saying it does exist. But if 36,000 municipalities of all sizes and all scales don't do what you're proposing, I think we should learn from that. And the study that I did that. You'll notice how I did it to avoid any bias in the study. And it concerns me that however you arrived at this approach doesn't seem to make any logical sense whatsoever. Now, even as Mr. Walton pointed out, even though the legislative at the state level says you could do this, no one in the state has actually done it. And they keep a separation. And I would point out, just as a practical matter, because Matt and I, at all the Planning Commission meetings, obviously there's a lot of discussion over the years. If I were the building inspector, if I literally had his job, I would still be saying the same thing. And I'm fairly qualified, far more than what our current law says what a building inspector, and it says he as opposed to not having any reference to gender. It says you have to be at least having graduated high school and have some awareness of the building trades. That's the minimum qualifications. In today's day and age, that's absurd. Now, Matt obviously has more than that, but even if I was running that department, you should not vest all the authority into a single individual to make such momentous decisions that require so many facets of background. Now, I happen to have 2 degrees in engineering, as well as a doctorate in urban planning and 50 years of experience. Even with all of that, you could not trust me if I was running that department. Not that you don't believe that I do a good job. I would try to do my best, but there are things that would be missed. And that's where you take, as they say, it takes a village. In this particular case, it takes a commission of multiple backgrounds, and that's important. Thank you.
Thank you, Mike. Next, anybody else? Actually, Earl, did you want us to say something? And then Rick. Introduce yourself.
Yes, hi. Thank you. I am Earl Stockdale, and I am a resident and property owner here in Rehoboth Beach. I'm also a member of the Planning Commission. I want to ask a quick procedural question, if I may, before we start using my time on the clock. I made a slight adjustment to my statement, which has already been submitted to the record. I would like to, if I may, substitute that.
Just
and then I want
resend it on Monday to Ann
she has a
in
copy.
electronic format. Okay, well, we have it here, but send it to Ann electronically also.
Okay. Thank you. Again, it's an honor to be here. As I understand the issue as it has now been teed up, we are considering moving forward with a vote on competing drafts of legislation now, or having a meeting to discuss going forward on that with the Planning Commission and the board beforehand. I want to say, please.
If I heard you correctly, we're not doing any voting today.
Okay.
okay?
Good. I wanted to,
Except that we would possibly vote to adopt a resolution setting a public hearing. It's not voting on building inspector version A, and it's not voting on planning commission version B. It's just considering adoption of a resolution, setting the public hearing date. And I propose December 9th would be the date. And at that point, the public hearing, that would have a broader public base probably, people that come and voice their opinions for one or the other. And then it could be at the conclusion, most likely, at the conclusion of that public hearing, then we would conduct the vote to approve most likely one or the other.
Thank
But
you.
it has to be done. I mean, we can't, I disagree with counsel that I suppose we could do nothing, and we have to do something.
thank you, Mayor. I think it is very important that you clarified that. What I strongly recommend is that we do not set a hearing date that closely, that before that hearing occurs, that there is a meeting between the Planning Commission and the board. And at that meeting, the full reasons and the need for the legislation are addressed. Frankly, I have seen no clear statement of the problems the legislation has been proposed to address. And I believe the discussion that has been teed up so far actually mischaracterizes the issue that is before the board. The issue is not whether authority should be given to the Planning Commission or to the building inspector. The issue instead is really whether an important check on the authority of the building inspector should be removed from the existing code. That check was thoughtfully put there and ensures that decisions about code compliance on very difficult, highly consequential, highly precedential issues are thoughtfully made after consideration of all stakeholder views, including the building inspector, the Planning Commission, and the public, and those views are set forth on an administrative record.
Thank you.
Thank
Carl.
you.
Thank you. And again, Rick is next, and then Tom. I just want to reiterate that I was hopeful for setting a public hearing on December 9th, but in mid-November, conducting a joint meeting if that's the pleasure of the commissioners. Identify
Yes,
yourself.
Richard Perry, 46 Pennsylvania Avenue. Could I just get a quick clarification, Mayor? I thought I heard you say that as to comments on the merits, that you felt those were appropriate at a public hearing, and you were asking for comments on whether or not you should go to a public hearing and the issue as to the involvement of the Planning Commission in a joint meeting. Is that correct?
Correct.
Okay. Let me address the bigger issue first. You've got a bigger problem than it seems to me that you realize. And while I would encourage a joint meeting between the Planning Commission and the Board of Commissioners, there's a Board of Adjustment. And I can tell you that at the last two meetings of the Board of Adjustment, the chair made it very clear that it is the Board of Adjustment that has the authority to interpret the code and no one else other than the building inspector. That was made very clear and forcefully. The issue was brought up as to whether or not a Planning Commission would appeal to the Board of adjustment if there were a disagreement between the Planning Commission and the building inspector. And the answer was, yes, they have the right to appeal to the Board of Adjustment. And it only makes sense, and I've also read Section 324 that was noted, and that statute would be meaningless if the Planning Commission didn't have the right and ability to go to the Board of Adjustment and ask for their interpretation. Beyond that, you've got the courts. So I would encourage you, although I know it's a larger group, but I think the Board of Adjustment is a necessary party to these discussions. And so I would encourage you to include them as well. I've been working on a response to many of the submissions that have been made to the Board of Commissioners. And there are some things that I feel do need to be cleared up, and I want to just make one of those points. A member of the Planning Commission, in her personal capacity, wrote a memo to the Board of Commissioners, and one of her assertions was that it was the Board of Commissioners that rushed this through because they wanted to influence the Belhaven decision. I just want to remind everybody that the Planning Commission raised this issue. They were the ones who amended their original proposal and included language to, in my view, take the power of the building inspector away. Thank you.
Rick. Tom?
Thanks. Tom Gaynor, property owner. Guys, this comes back to the power issue I mentioned earlier. So Commissioner Thier, Ed, Don, Suzanne. December 9th, in the middle of the holidays, for one of the most critical issues you probably are facing on the agenda right now, seems a little bit rushed, particularly during a time of year when most people are distracted. And we've seen that the issues related to the Planning Commission are legion. They have not only held up the economic redevelopment of some of this most significant pieces of property in this town that would impact everybody favorably, but then also certain ones in this room were instrumental in putting in provisions that were outside the scope of the law, outside the scope of their authority, and resulted in litigation. So this is a much bigger problem to be handled, I think, in the surgical way you're trying to address it. And I agree with Rick. This is a multifaceted problem that needs a little bit more contemplative approach than, I think, rushing it into a public meeting with a potential vote a month and a half from now in the middle of the holiday season, Stan. It's got too many consequences that are too big for everybody. And it comes down to the four of you to work together, if the other three don't, to table it and get control of the agenda here, which I hope you'll do.
Anybody else? Susan?
Thank you, Mayor and Commissioners. My name is Susan Stewart. I am a Planning Commission member, but I'm not in here in that capacity. I'm a resident. My appearance today concerns my concern about broader governance and power issues within the city and the commission. It appears that this was proposed, you proposed the amendment, Mayor, unexpectedly last month without prior consultation with many commissioners, certainly at least the two commissioners who were sworn in the day that the amendment was to be discussed. That process sidelined several of you, exceeded the mayor's authority, and lacked transparency. The effort culminated with the hiring of an outside attorney to push the mayor's desired outcome, regardless of your wishes. I understand that certain commissioners are worried about power being vested in the Planning Commission, which, think about it, it's a 9-member board with rotating staggered commissions. I would be more concerned with political pressure of one person, a building inspector, employee of a city governed by a mayor, a city manager, and a very powerful former city solicitor. Are you commissioners okay with that? Do you want to have input As a voter, I'm not okay with having one commissioner run the show here. There are serious governance issues in our city. One, the city solicitor resigned last fall, yet the mayor remains extremely dependent upon him. It's going to be interesting what the legal fee shows. I hope they're shown by who provided the service. Two, the new city solicitor is employee of the firm managed by the old city solicitor, and as such, is dependent upon him for continued employment. Three, an outside attorney was hired to press the mayor's amendment, and it is unclear whether commissioners participated in that decision. If not, that's a governance issue. If you did, and it didn't happen in public, that's a FOIA violation. Four, the attorney for the Planning Commission, also employed at the same firm as the current city solicitor and the former city solicitor, is removed despite his desire to continue to serve on Planning Commission. What's going on? Commissioner, these events should concern you much more than any authority of the Planning Commission. Please take back your power to participate in the governance of the city. We shouldn't be talking about this amendment that jumped on an agenda 2 months ago. If you want to have public discussions, workshops, let's do it. There are so many misstatements of fact here. Mayor, I'll leave that one. Thank you.
Would you send your letter electronically to Ann?
I will. I'm going to edit because there was a last part that I think I probably shouldn't say.
There. Okay.
And can you put the computer on the screen? Thank you.
Are you going to take your full allotment?
Well, no, I'm not. I'm going to, I heard what you said about the, hold on a minute. I'm just trying to get mine up here. I had prepared, as some of you heard, a PowerPoint for today, which I'm not going to give because, first of all, I couldn't do it in 3 minutes. I'm Susan Gay, city property owner and vice chair of the Planning Commission. However, there are three, and a lot of these issues, it's important background information that you all would need, certainly before a vote.
Excuse me, Susan, on whose behalf are you speaking today?
I'm speaking on behalf of my experience on the Planning Commission.
So as a citizen?
I am speaking as a citizen and as my role of vice chair of the Planning Commission.
Okay, thank you.
All right. Okay. So much of the information I would impart to you today would be appropriate for the joint meeting, and I want to say right off the bat, I appreciate you doing that. There are 3 slides that are relevant to the timing of the meeting and to where we are, and also to correct some misinformation. So I'd just like to do those. And that is, as you know, we submitted revisions for the entire Chapter 236, and those have not been heard yet. The only time they were heard was at the May 6th workshop, when the agenda item is there in bold, that the discussion was limited to 1 section. And in that meeting, and that hasn't been all that long ago, some of you may remember it, the mayor did promise that we would have 2 more sessions to present the balance of content. In addition, he said that the meeting was introductory and that the conversation would continue. Nothing else was heard at all on that until last month when the ordinances were suddenly introduced. So I am grateful that today there's been a promise made to continue that conversation with a joint meeting, because we first requested a joint meeting about a year ago, and I am grateful for the opportunity to have it. And I also want to just put this in context, because there's been a great deal of misinformation about what it involves. Last Friday, the chair of the Planning Commission, Mike Bryan, myself, met with Mayor Mills and also with City Manager Tedder and Assistant City Manager Evan Miller. And the mayor started off that meeting with a little summary of the timeline, similar to what's in your packet today. And at the end of that statement, he said he was under the impression that the Planning Commission was trying to take over the Building and Licensing Department. I was absolutely flabbergasted, and I told him so. I said that is absolutely not true. And then I turned to the city manager and the assistant city manager, and I said, do you understand that this is only about site plan
Mayor, if I
review?
may, I would suggest that you address your comments to the chair of the board and not to the public.
Okay, I'm just looking at the public. I'm not addressing.
This is a Board of Commissioners meeting, and we expect you to respect that.
So, what I said was, microphone.
Stop our clock. Thank you.
Thanks.
Well, Commissioner Preston, we can agree to disagree. But Mayor, I'm going to go back to the statement that you made at the beginning of this meeting, which is that we're going to treat individuals with respect. So I think it's important, whoever it is, whether it's up here or the people down there, that that occurs. And I'm questioning whether his comments treated this resident with respect. I'm not sure that the comment even needed to be made.
Mayor, I'd like to respond to that.
Let me finish. The speaker can really look wherever they want, okay? If they want to look up here, they want to look at the audience, that's their choice. Go ahead, Don.
So,
I'm sorry.
Mayor,
Go ahead, Commissioner.
Mayor,
Preston.
when we had our, at least when I was onboarded as a commissioner, we were given a significant sized notebook, 3-ring binder, with the way we conduct ourselves. One of those is Robert's Rules of Order. And if we take the time to look at Robert's Rules of Order, when somebody is addressing a legislative body, they address the legislative body, typically the chair. It is not to address the public. So this is not a complaint at Susan. It's actually, you and I've had this discussion a few times now, that when people speak at these meetings, they need to address the Board of Commissioners. Otherwise, run for office, sit up here, and then speak to the public. So, Commissioner Thier, this is not about this particular moment. It's about a recurring theme of disrespect for the Board of Commissioners. So it's something that I think we need to regain control of.
Let's move on. Susan,
Okay.
why don't
Okay, let me just finish this.
anybody else address
Yes,
us?
I am addressing you all. I'm addressing everybody, actually. But anyway, I'm trying to clarify. Site plan review was adopted in June of 2009 to only look at large, complex commercial projects that have the potential for an outsized impact on the city. And to date, in 15 years, there have only been 8 applications come before the Planning Commission. 4 of those have been approved, and I might add 2 of them have been approved this year by the current Planning Commission. Some of that is obviously based on timing of the applications, but nevertheless, we are moving through the process expeditiously, and I'm pleased with the work we have done. So I just want to put it on the record that the scope of what we are talking about is limited only to site plan review, that in fact, the building inspector makes binding decisions on code every day of the week with residential plans, small commercial plans. We are not talking about his authority. We are not taking over anything. We are talking about code-provided language of how we deal with complex projects. And since I was interrupted, please let me just do this one. And that is, what I want to talk about at the joint meeting is some facts that you all may not know, and that is that lawsuits against the city in the past are from mistakes of the building inspector costing city taxpayers over $1 million. They're not from mistakes of the Planning Commission. The Planning Commission's actions have been upheld in the courts. Secondly, and this goes to what the attorney here talked about and what Mike Strange talked about, which is the extensive research he did with other communities. And while it may be true that the state code includes some general language about who can apply to the Board of Adjustment, the fact is that the language in your ordinance requiring us to go to the Board of Adjustment is nowhere else in anyone else's code, nor is the absolute power to interpret the zoning code for the building inspector. And I look so forward to having a joint meeting and being able to really go over all of this and figure out with the building inspector, figure out some efficiencies of task. Thank you.
Anybody else? Harvey and then Nan.
I'll erase this.
Your name?
Harvey Schulman, property owner. Thank you, Mayor. Until the former city solicitor claimed about a year ago that the Planning Commission interpretation of the zoning code could not supplant the building inspector interpretation, nobody ever contended that seriously. The fact is, and Mayor, you know this, and Commissioner Gosselin knows it because you were there in 2009, the site plan ordinance does give the Planning Commission the authority to make the final determination in the context of a site plan review what the zoning code means. And that was specifically added. You know this, Mayor, and you know this, Commissioner Gossett. That was specifically added to the site plan ordinance in its last draft. You want to see it? I've got all the multiple drafts. And in the end, because it was the question, well, does that mean who can interpret the zoning code? You all added on a 6-to-1 vote, Chapter 270. Not just the Planning Commission interpreting state law, federal law, and city ordinances, but you said in Chapter 270, you put it in. Now, Mayor, you were the only person who voted against that. That was a 6-to-1 vote in June of 2009. People like Commissioner Kuhns, Commissioner Caluzzi, Commissioner McGinnis, nobody would accuse any of those people as being in favor of empowering the Planning Commission, and minimizing the role of the building inspector. But they joined others, including Mayor Cooper, to pass the ordinance giving the Planning Commission authority specifically to interpret 270. And you voted against that, Mayor, and you gave the reason at the time you didn't think the Planning Commission should have that authority. So if anyone looks at the law and the history of the law, let's not confuse things about it's ambiguous. It's not ambiguous. You can do nothing. This reminds me of a famous person who said, well, it depends what the meaning of is. You can take anything and claim it's ambiguous. This was not ambiguous. And why was the Planning Commission given that authority? Because we know from history with subdivisions that about 25% of the time that the building inspector came with his or her view on the zoning compliance with subdivisions, the building inspector was proved to be wrong. Not because they were incapable, but they didn't have the evidence, the questioning, and how does the building inspector make decisions? The building inspectors are good people, but they're allowed to, and they do, go in a small room with a developer, with the developer's lawyer. The public is kept entirely out of that, and we knew that led to enough errors. And if I may finish my sentence, and that's why you gave the Planning Commission this authority. You didn't want those backroom conversations taking place. Okay, so I urge you not to move ahead with this because the code doesn't need clarifying. Just apply it the way it's always been applied until the former city solicitor a year ago came up with some reason.
Thank you, Harvey. Thank you, Harvey. Nan?
My name is Nan Hunter. I'm a member of the Planning Commission. I'm here in my personal capacity. I want to emphasize a few things. In addition to what Mr. Schulman, also a former member of the Planning Commission, just said, this rush, this sense that it has to be done, it has to be done quickly, it frankly is manufactured. This process has been in place since 2009. There have been few, if any, complaints about the treatment that applicants have received, other than one particular application. That is it. The statement was made that there are all these examples of the Planning Commission engaging in delay and obstruction. Not true. It reminds me of the last time we discussed this, which was last month. Allegations were made, and it's funny, they haven't been repeated. Why? Because nobody has taken the opportunity to stand behind clearly false allegations. For example, the allegation that the Planning Commission isn't accountable to anybody. Well, it's a product of state law, of city law. It is bound by the Open Meetings Act and by FOIA. It conducts everything in public, unlike one particular employee of the city bureaucracy who is subject to many pressures and is not subject to any public accountability. And that is really the issue before you. Another example, I remember Commissioner Shinowski asking Mr. Walton, well, isn't it true that no other jurisdiction allows the Planning Commission to overrule the building inspector? And Mr. Walton said, well, no, actually, that's not true. There are many versions of these laws. Well, now we have additional research indicating that there is no jurisdiction that gives the office of the building inspector, an individual who is required to have a high school degree, the authority to make a final determination on something as complex as the zoning code requirements for, not for who paints their house a particular color. I mean, let's be serious. For large commercial projects, the kinds of projects that will determine the character and quality of this community for all of us forever. All right? No other jurisdiction. That should tell you something. And the last point I'll make is that do not rush to a public hearing on a text, on a legislative text that you didn't see until, what, 48 hours ago? Those are the kinds of processes that lead to mistakes and that this commission should reject. Thank you.
Thank you, Nan. Anybody else? If not, we'll bring it back to the table up here on what's your pleasure. Again, if we were to move toward a public hearing, December 9th would be the timeline. I do suggest that if we go with a joint meeting between the Planning Commission and the Board of Adjustment, Board of Commissioners, that I will throw out some dates there and check with Planning Commission members and Board of Commissioners mid-November would be the timeline for that. So I need to hear from you all what your pleasure is. Did you want to offer anything?
I do not. If there's questions, I'm here to answer them.
Mayor, me?
Anybody?
I guess I'm curious about what would be the difference in the two sessions?
I think we have the joint meeting while we hear from the Planning Commission, and they expound on some of what they presented today, if not redundant perhaps, and then the public hearing, maybe they would have less to say because they've said it at the joint meeting. I don't know, but, you know, we've got to remember that part of this involves Chapter 270, which is in the zoning code. So any amendments to the zoning code have to go to a public hearing. So that's a requirement. The joint meeting, that's an optional thing. Could it be beneficial? Absolutely.
Would it be, the joint meeting would be held in public forum?
Mm-hmm. Anybody?
Yeah, so
Commissioner Thayer?
Sure, thank you. So I think one of the things that I learned is, Mayor, I apologize. Mayor, though you disagree with Max in terms of the urgency of this, what I've learned, it's clear that, you know, there's not as much urgency as you're suggesting that there is. I think there are some steps that need to occur before we get to a public hearing, and I think we need to make sure that we allow sufficient time to get to a public hearing. I don't think, as I've said previously, I don't believe that moving authority from the Planning Commission to the building inspector solves the problem, okay? And I think we need to be focusing on the problem. And I think the joint meeting, and I tend to agree with Commissioner Preston, so see, we do agree, that there is at least a third party here, and I'd suggest a fourth party that also needs to be included. So the third party, is Commissioner Preston said, is building and licensing. And I would say the fourth party is, there is a fairly extensive study that was done, that was initiated by Mr. Christian and done by Wallace Montgomery, which came back with, I don't know, 60 plus code recommendations, I think on 236, a series of pretty detailed process flows for the building and licensing department, which I don't know have been implemented, but in a whole total scope here, whether it was the code or the process flows, it was Mr. Christian's attempt to get at resolving the issues that we're talking about today. Mr. Christian, and I'm going to read verbatim from, it was the April 11th, 23 Commissioners meeting. Mr. Christian states that he, the Assistant City Manager, and the City Solicitor had all looked at the code and all had different interpretation of the process as you're going through it. As, again, citing concept review as an example. You pull different nuances from the code, and it's just difficult to follow. So I think we've got a much bigger, I don't want to say a much bigger problem, but we've got a more extensive problem here that needs to be addressed. I think we need to have meetings that include, and I'm not sure that it's one meeting, because if we put all of these four parties in the same room, it's going to be difficult to get anything done. But there's us who clearly make the final, I don't want to say clearly, there's us who make the final decision. There's the Planning Commission. There's Building and Licensing, as Commissioner Preston suggested. And then there's Wallace Montgomery. Because I would like to hear I would like to hear from Wallace Montgomery on the results of this study. It's my understanding that this study was, once this was completed, it was never taken up at all by the Board of Commissioners. I think there was some type of presentation, but beyond that, Mayor, no action was ever taken. So I think we need to revisit this as well. So I think there's multiple meetings, because I'm reluctant to get four parties in the same room at the same time. And those multiple meetings are going to take some time. I think, as one of the residents expressed, December 4th, it's tough, right? We're getting into the holidays. We're in between Thanksgiving and Christmas. Multiple meetings are going to take, we're going to need more time than 30 days to get there. So I think we need to schedule these meetings expeditiously as possible. And after we get through those meetings, then we come back and we set the hearing. Look, you've given us a binary choice, right? I mean, one of the things that I'm very, very uncomfortable with what's being put in front of me is that there was never any discussion, not even, I'm new to the board, but really never even any discussion amongst the commissioners, okay, about what the path forward should be. You jumped ahead. You spent a lot of money on legal fees with Max Walton with literally no discussion whatsoever on this topic. So based on what you want to do, we've got a binary choice, and who's to say that when we go through these meetings, we're not going to come up with some other decision. I want to fix the problem, and that's what I want to focus on doing here. So my recommendation is we set up these joint meetings. We can figure out, of these four parties, how we structure these joint meetings. Once we get those through those joint meetings, then we, as commissioners, it's our responsibility to make the decision. We then decide A, B, or maybe there's a C and D out there.
Anybody else?
Mayor.
Good. And then Bunky.
Thank you, Mayor. I worry this will take a while, whatever the outcome, but I think in the short term, I think I'd like to actually plead with the Board of Adjustment, unless there's demonstrated hardship on the applicant, to stop granting variances which are so far above the what would be the code compliant version. I mean, we just had 2 days ago a satellite parking lot, which is so beyond the 700 feet to the entrance of the proposed Bellhaven that it's just not even in the ballpark. So to help stem this endless series of variances, which I think are not, it's the usual sort of way of doing business here. The developers view our building code as just a starting point for negotiations. So because I believe this planning commission authority decision will take a while, I would like to see the Board of Adjustment be a little stricter in its decisions. It was 3-2 on Wednesday. I would have preferred it had been 5-0. Thank you.
Anybody else?
I'm sorry, 0-5, I'm sorry, 0-5 against a variance.
Well, from what I'm hearing, I think we're going to, oh, go ahead, go ahead.
Thank you, Mayor.
Was Bunky first?
yes.
Well,
and
the
then,
only,
Commissioner
only
Gossett.
comment, my experience in this whole, in what we've seen so far is my inability, which I have inabilities, I recognize that, but I don't know why we're here and how we got here, and that's troubling. So, we last voted. I voted against us moving forward on this. We're still moving forward on this. I am not convinced. I'm more in agreement with the status quo, and that sort of like maybe counters the urgency aspect. But I am clearly in concurrence with Commissioner Thier that we need as little time as we have and so forth. We need to get a thorough analysis of this and know where we are. And so I am more supportive of a joint meeting or several meetings and get through this thing, and previous work done by our previous city manager, I think, would be useful and helpful.
Thank you. Commissioner Gossett?
Commissioner Chernowski.
Thank you. I'm certainly in favor of a joint meeting. Having a joint meeting probably sooner rather than later. I think there is some facts and circumstances which were brought to light today that I certainly want to do more homework and fact-checking on. But I do think that we need to lay this issue to rest and move to a public hearing in the near future. I don't know that it's appropriate to set that date today, but I do think we need to move forward and get everyone, the Planning Commission and the Board of Commissioners, seated around the same table having this conversation.
Thank you.
I'm sorry, the one group that we haven't heard from is Building and Licensing, and I would very much like to hear from them, if not today, and their point of view on this soon.
Thank you. Commissioner Gossett?
Yes, thank you, Mayor. Just to address Commissioner Preston's question about what would be the difference in I believe it was a joint meeting and an actual public hearing. I think a simple phrase would be conversation. At a public hearing, it is 3 minutes, up, down, in, out, present. I think the way politics is working today, that we're not talking to one another, we're talking at each other. A joint meeting of a conversation around the table of all people present, a position at the table to be heard, to have a conversation, to really kind of dig into this. I think that would solve a lot of the problems that we're experiencing on many levels here. If you would talk to one another as opposed to talk at one another. So I would be very much in favor of a joint meeting to be scheduled in as soon as possible, with all participants being able to participate. Either, I'll throw it out there, I know the mayor does not care for this, but to participate by Zoom also, to make schedules workable. But I do also feel that setting a public hearing today with a date that he suggested of December 9th is putting a false condition on us in that we have a deadline to meet, when this is a major discussion we're having about zoning codes that affects many, many people. I don't think that setting a date to meet just to set a date is wise, and it will impact on the decision-making process and the conversation process that we need to have. Thank you.
Thank you.
Mayor, just to follow up, since
Commissioner
I asked the
Preston,
question about the difference, and Patrick, I appreciate your comment there. I agree with you. I also agree with Commissioner Thier wholeheartedly on this, about the underlying issues. I think one of our commenters said that these are big and consequential issues that underlie this, and I think that's true. And I think when this was teed up in May by the Planning Commission, who came to us and said that they needed us to address a few things, I don't think we, as a body, ever dug into what are the real issues. I'm a bit disappointed that we did start talking about this in May, and then it was apparently nothing happened, at least as far as I know, since then. So sure, if we want to restart this and have a roundtable discussion about the real consequential issues that are at stake here, including simple things like what are the qualifications of a planning commissioner? What are the qualifications of a building inspector? Are they up to date? Are there any? I don't know the answer to these questions, but I suspect we'll find that they're either outdated or they don't exist. And that can't be. So if we're going to have that sort of robust discussion about sort of fundamental things, what's broken in the code? What does Wallace Montgomery tell us in 66 pages is broken in the code? I think the staff has been working on process in building and licensing based on the Wallace Montgomery work, but I don't know for sure. So if that's the kind of discussion we're going to have, I think we should do it. And as many of them as we need to do to be thorough.
Mayor, if I may, just a point of reference there, looking at the deeper problem, if you will, is my belief that it is the code. Okay, the code that we adopted was November 4th, 1974. There are people seated up here at this commission that weren't even born then when this code was adopted. I'm not saying that's good or bad, but anyway, I just think that is really the area to dig into. In the 1996 Land Use Plan, the 2000 CDP, the 2010 CDP, the 2020 CDP all address the issue of updating the code. We have done, to use a phrase, bupkis on that at all times. I think this is the opportunity that has brought it to a head to have a conversation about that, whether it be on the aspect of Planning Commission versus building and licensing, or it really is delving into the code. The buildings built today, we are trying, and the building inspector and the staff in building and licensing are trying to shoehorn those requirements into 1974 codes. There's a lot of things that have happened between now and then. To me, that is the real key we need to look at. That's a much deeper process, but I don't want that to be off the table also. Thank you.
Commissioner Thier?
Yeah, so I think it's important that we keep on task here, right? So I think there's at least one joint meeting, which would be between us. And again, I'm throwing this out here, right? Because, and again, that's not what I think. I think this is a discussion that we have to come to some, again, my point here is we have to keep on task. So we have to make a decision on what the next step is. So one of the, one option that's been discussed is the commissioners, Planning Commission, and Building and Licensing meeting jointly together. I've mentioned Wallace Montgomery. Adding that to that meeting, I mean, I would, to the extent that we could get a representative from Wallace Montgomery here to present their findings with the Planning Commission here, with us here, I would find to be very beneficial, because my sense is that once we get into Wallace Montgomery, I'm going to have questions for the Planning Commission and vice versa. So do we have this one larger meeting with all four of those parties, or does it just become overwhelming? My concern, it becomes overwhelming, but again, the point of this comment is to keep us on task. So I'd like to hear other people's thoughts on what you think would be the appropriate next couple of steps.
Well, I think you've got a good formula, but I think it might take multiple meetings. I mean, you get 4 agencies in there, that's a lot. That would be a special meeting, so we allot ourselves X hours for it, rather than stick it in on one of these meetings. But
I see the overall issues with our code being separate from this authority issue with the Planning Commission, Building and Licensing, and Board of Adjustment if they're involved.
Commissioner Sharnowski, I do not disagree with you, but I just don't want that to get off the table at any point in the future, that the code is really what we need to,
Yeah,
to review
absolutely.
at the future. My suggestion, if we may, is the process, as Commissioner Thier responded to, but to develop the responsibility to develop an agenda for this joint meeting. Who would that fall to? Would it be a representative of the chair of the Planning Commission, the mayor, the city manager, some solicitor involvement, Wallace Montgomery? I'm just asking that out. I do not have an answer for that, but I think any meeting that goes forward without a formal agenda is time misspent. So I think that needs to happen with some specifics of roles, responsibilities, and what we expect to get out of that particular first meeting. Thank you.
Thank you.
Mayor.
Commissioner Good?
Thank you. I have some trepidation hearing all this. I think that we're now arranging for a consultant to run a series of meetings, and I'm not sure how much will be accomplished that will be concrete. In general, I think there's some diminishing returns now to however we handle big projects, because with the possible exception of Baymart, which has a lot to do with an irascible and eccentric owner more than the actual like parameters of how to put together that, I think it's 7.8 acres. I'm not sure there will be that many large commercial projects in the next couple of years. So I think I support Commissioner Sharnowski and others who do think we need to revise some of the code. But I'm very concerned about running a series of meetings with Wallace Montgomery leading that, because in the past it hasn't led to any real actionable solutions. Thank you.
Thank you. Anybody else?
Just, if I may, Mayor, one comment on that, just as a perspective. You talk about large parcels. True, Baymart is the only large parcel, but there are multiple developers out there buying pieces of property under different LLCs, amassing these to develop other properties, larger scale properties throughout the city. This may not happen tomorrow, it may not happen in 3 years, but 5 to 10 years it certainly will happen, as we have seen the change in the boardwalk right now. But I would also suggest, if you're concerned about Wallace Montgomery presenting or what have you, they have made a full report. If that report could be shared with all the commissioners, and again reminded from the Planning Commission and Building and Licensing, I think that would be a helpful start to get our homework done to begin the opening of that meeting. Thank you.
Thank you.
Mayor, I'd also suggest, I think I've asked for this many times before, we jump around and have meetings, and then there's huge periods of time where we don't talk about something, then we come back, there's this memo, that memo. If we could have a timeline and outline of when things were discussed in meetings, when memos were sent, with links to go back and reference those memos, an outline of everything involved in this subject matter so that we can easily go back and reference things, I think it would be incredibly helpful for me, rather than wasting a ton of time going back and doing my own research and fact checking, etc. So I would just ask that might be part of the process going into this joint meeting.
Yeah, I would ditto that. It's just a ridiculous amount of time that we have to spend doing research when there's information that really should just be served up to us.
I will point out, though, I believe the agenda item report for today's issue has a lot of that information in it. It is not quite as in-depth of links or that nature, but it does lay out chronologically of the start of it from August 22nd of 2022.
Okay, we're going to bring this to a close, and we've got some direction here. I think what I'll do is meet with the city manager, and we'll meet with the Planning Commission chair and devise a plan going forward.
I mean, I'm risking a little bit here, but I think we should set, maybe we can't, I appreciate we can't set meeting dates today, but I think we need to set deadlines, right? So we're going to have this meeting no later than such and such a date.
We'll look at that.
Okay.
Yep. All righty. Thank you very much. Thank you, Max.
May I be excused, Mayor?
You may be
Thank you.
excused.
Have a nice
I
weekend,
know
everyone.
You've got a 2-hour drive home. Thank you.
Thanks, Max. It's good to see you.
Is Mary Ellen we're gonna resume our sequencing here, and the next item of business is departmental briefing reports. We've got certain support documents embedded in the agenda for the alderman, code enforcement, and police department. Separate from that is planning and development department presentation by Planning and Community Development Director Mary Ellen Gray.
Okay. Good afternoon, Mayor and Commissioners. Thank you for this opportunity to present the Planning and Community Development Department. Given the long agenda today, I'm going to keep my presentation at 20 minutes, so I might be breezing through some of the slides, but you'll have them for reference. My presentation is going to discuss the Planning Department organization and the fabulous Planning, Community, and Development Department team who have joined us today. We have most of them here. Some of them are back in the office attending the front desk. What we do every day, some data for a planning presentation would not be complete without a discussion on data. The current projects we're working on in the department, and finally, future projects. Here is a Planning and Community Development Department team, which has 2 divisions, so to speak. The arborist, which is currently vacant. Would like to say earlier this week, we received word that the arborist position has been filled, hopefully, by a gentleman named Michael Lilly, who is slated to start in mid-November. We will be introducing Michael when he comes on board. The Arborist Department includes the Recreation Supervisor, Tim Banforth. Tim, if you could give a wave. Tim. And Laborer Mike Peterson. Mike, thank you. The Building and Licensing Department includes Chief Building Inspector Matt Janis, who went back to his office to do some work, or Corey Shinko. Corey. Thank you. Code enforcement officers Scott Canalupo and Amanda Pombo, as well as permit coordinator Joanne Perry, and Joanne is back in the office, and administrative assistants Maria Santistefano and Sherry Jevnik. So what do we do every day? To be clear, these job descriptions are general, and my remarks will hit the highlights. In addition, as with any small department, we also do a lot of performance-related work as required. We all work as a team, and there isn't anyone in this department who doesn't hesitate to pitch in and help figure something out or get something done as needed, whether it be for this department or another department. The director position reports to Evan Miller, the assistant city manager. The director role is one of managing staff and work for the department. This position assists with the administration and implementation of the City of Rehoboth Beach Comprehensive Development Plan, otherwise known as the CDP. But also this position must look at the big picture and be forward-thinking regarding planning issues in order to provide competent advice and be a technical resource in planning, which also requires communication and working with the mayor and commissioners, boards and commissions, committees, staff, business owners, developers, cities, state and county officials, and agencies and the public on short and long-range planning related aspects of the community and department. The arborist position interprets and enforces the city tree code, including issuing and reviewing permits, reviews tree plans for new construction projects, and oversees compliance. This position also supervises the activities of staff and contractors involved in planting, maintenance, and removal of city trees, as well as landscaping in public places. The Recreation Director, Tim Banforth again, this is a year-round part-time position. Tim supervises and oversees the summer recreational activities which was, as reported in the biweekly reports this summer, we had record turnout. Tim also ensures that the city public spaces are effectively maintained, and he also works throughout the city on beautification projects such as plantings in City Hall and the bandstand. Mike Peterson's job as a laborer is to manage the landscaping and related greenery in our public spaces, and Mike also helps Tim in his projects as well. Moving on to the building inspector, which we talked a lot about this afternoon. The building inspector positions held by Matt Janis and Corey Shinko. Matt and Corey review building permits, building plans and permits to ensure that they meet the applicable city code and building rules and regulations prior to permit issuance. Matt's position focuses on the commercial side, while Corey focuses on the residential side. Matt's position also reviews plans for conformity with the city code and other applicable rules and regulations to be heard by the Board of Adjustment and the Planning Commission. Corey's position also reviews plans that are heard by the Board of Adjustment as well. Both Matt and Corey work in the field performing inspections to ensure that buildings under construction are being done in compliance with applicable code and regulations. And per their job description, I just want to add, since there's quite a bit of discussion on this evening, that there are also quite a number of certifications that they must maintain, acquire, and maintain through the International Code Council.
Director Gray, if I may interrupt one quick thing. Is there any cross-training between those positions?
All the time, yes, sir.
Thank you.
Permit coordinator is Joanne Perry, and she reviews and issues permits for the less technical, but just as important, permits including signs, permitting such as plumbing and kitchen and baths and siding and roofs, and as well as business licenses. Joanne also manages the yearly mailing for the renewal of business licenses and supports the front desk with inquiries and response to complaints. The code enforcement team of Scott Canalupo and Amanda Pombo inspects buildings and sites for compliance with property maintenance and building codes and responds to complaints and inquiries. They issue warning notices and notices of violations with the goal of working towards compliance. They ensure work quality and adherence to established policies and procedures and establish and maintain effective working relationships with contractors, property owners, representatives from other agencies, as well as members of the public. And last but not least, our administrative assistant team of Maria Stantostefano and Sherry Jevnik. Maria and Sherry are the front line of the building and licensing department. They process all the permit applications, schedule inspections, respond to customer inquiries, fill complaint calls, and provide administrative support to the department. They are the glue that keeps us all together and the department running smoothly. Now on to data. I must say that as a planner, I geek out on looking at data and turning it into information that can be used to help the city make informed decisions. Given my now coming up on 1 year, it's going to be a year next week with the city and with Arbor's position soon to be filled, a big yay on that. I plan on spending more time looking at our data and discerning trends. These data that I'm about to present are a starting point, and I thought it would be helpful to share with you all for discussion and to see whether there's any other type of data that you would like this department to start looking at. First is some baseline information. This is pulled from the Comprehensive Development Plan, otherwise known as a CDP. The first is a population, and as with everywhere else, our population is continuing to increase. In 2010, our population was 1,324, and it's currently 1,578, with estimated to go up in 2030 to 1,763. Our housing units are 62% of 65% are single-family dwelling units, and that's 2,064. And our multifamily dwelling units are 32% of our housing stock, for a total of 3,305 housing units. Housing occupancy, this is also taken from the CDP. Out of our 3,305 total housing units listed, 23% are owner-occupied, and 92%, or 2,361, are available for seasonal rent. And this is certainly indicative of the city's seasonal resort nature. Moving on to housing age, still staying with the CDP, What this slide is indicating is that 45% of our housing stock was built prior to 1970, and 20% was built since 2000, with an average of 24 new homes being built every year. And further slides are going to be talking about the additional information on housing stock. So parcel counts by zone. This map was generated by our IT director, Max Hamby. This map not only provides a good baseline for providing the number of parcels in each zoning district, but also answers a question that was previously asked by the commissioners regarding the number of parcels in a commercial district, which are 288. And our residential district parcels are 1,999. Moving on to another map that Director Hamby kindly put together for me is the rental licenses in Rehoboth, keeping in mind that some properties have more than one license. So for apartments, we have 568 rental licenses, and we have 646 rental housing licenses. And these are the type of data that I would like to generate more of, utilizing our data pulls from Munis and other sources and mapping them. Because I think that these data points, when you start to map it, that really turns our data points into information.
Quick question.
Sure.
If I could, please. So you're showing us 2024 data. Sorry.
Yes.
Thank you. Showing us 2024 data. I'm guessing you have prior year data as well?
For the rental licenses?
Correct,
Yes,
yeah.
up back to when Munis started, when we started Munis in 2000. I have it on a future slide, I think in...
Have at least 30 years of history?
28, thank you, 2018, thank you. I don't
Thank
know
you.
the slide. Since 20, well, we have data going back from 2018 in our current Munis system, and it's a little bit more harder to get information previous to that. But some of the information can be discerned from our other databases, yes.
6 years is good.
Okay.
So, thank you.
You're welcome.
I just had a question about how is it through Munis that you're able to capture this information?
Yes.
Okay. Is that something you've had for a period of time? I'm sorry. Is that something you've had for a while or has been improved or enhanced in recent years?
So we've had the ability to pull information from Munis, but as we learn to use Munis more, we're putting more data in there. And also with working with Max, and he's using this is called ESRI, and the interface. So we're utilizing it more.
Okay.
So yes.
Thanks.
Commissioner Gray, if I may also, on that, this is a snapshot of 24 residential rental licenses.
Yes.
And just on your next slide there, you've come up with total rental permits. So I'm just curious, looking at those, comparing those two
Right.
numbers, we've got like 60% of the available homes for rent with rental licenses. Is that something you want to dig deeper into as data
Yes.
goes forward? Because it seems odd in a summer resort that 40% of our available homes don't have rental licenses. They possibly could or possibly not, but I'm just curious.
Yes, that's on my looking ahead slide. Yes. So the business license data, some data regarding our rental permits. We have internal rental permits, as I just mentioned, 1,492. Our general contractors, 648, and our total business licenses are 2,738, with our restaurants of food with alcohol of 64. So moving on to permit data, for FY25, that comprises 6.8%, according to our finance director, that comprises 6.8% of our city budget. In 2021 and 2022, I'm looking back at the last 5 years, those were the highest years for our permit fees, with 2021 being a little over 1.125 million, and for 2022, a little over $1.443 million. For this given year, our permit fees are a little over $630,000, and that's about halfway through the year. So it's possible, it's probable that our department will come close or likely exceed the 2023 permit fee of close to $1 million.
Just to confirm, this is based on our fiscal year, correct? Not a calendar year?
Actually, I was looking at calendar year. So for commercial development, and certainly I could recalculate the data on fiscal year as well.
I think that would be much more beneficial for budgeting.
Sure, absolutely.
Alignment when we're doing the budgeting process.
So for commercial redevelopment, the last set of data looks at the last set of data I have looks at commercial and residential redevelopment. For commercial redevelopment, commercial renovation permits, these are just closed out permits. We have a number of other permits that are in-house that we're currently processing. So for commercial new construction, obviously it's the Beach Patrol building, and I had a fabulous picture of the Beach Patrol building, but I don't know what happened to it in the final, I don't know. Anyway, it was in the draft. So for commercial repair, we processed, closed out 322 permits for construction value of $11.6 million. And for the commercial addition and remodel, we processed 189, closed out 189 permits with a little over $16 million. With some notable projects being obviously the Beach Patrol building, at the Coast Hotel, that was a close to $5 million project. The renovation of this ongoing renovations of the Sands and the Henlopen condos, as well as the renovation of the Chesapeake and Maine, did some renovation, and the new restaurant of Baja Bob's. I don't have a picture of the Baja Bob's here. So the site plans have been approved, and I think Vice Chair Gay mentioned this, that we have, two plans have been approved as of late, well, in the past 5 years. We have the three mixed-use buildings on 413, 415, and 417 Rehoboth Avenue. Those are mixed-use buildings with commercial on the first floor and 2 upper floors. And of course, the Bellhaven Hotel, which is a 4-story mixed-use development that has 92 hotel rooms, restaurant, and retail shops, along with underground parking, with a total square footage of a little over 114,000 square feet. So last slide on the data is residential construction and new residential builds between May 2018 and October 1st. New home builds are 147, and what's an average of 24 houses a year. And you're going to be seeing that data shared in the code enforcement presentation as well. Residential renovation during the same time frame, and we just looked at additions and renovations over 100,000. There was 135 projects. Residential demos 119, and residential house moves was 7. So moving on to current projects that we're working on in addition to our day-to-day duties. For the first year, I focused on onboarding with the city, getting to know the city functions, board, city staff, and the like, and the ordinances and regulations. I also worked with the code enforcement team on developing processes and procedures for a code enforcement program, as well as understanding current business licensings, permitting, and site plan review processes, and seeking ways to improve and streamline, and worked with our consultant strategic solutions, which I'll talk about in a future slide here in a minute. I also participated in some community outreach efforts, which I'll plan on doing more of, making presentations to the Rehoboth Beach Homeowners Association, with one of them in conjunction with Corey Shinko, regarding unlawful basements. Also coordinated with the Rehoboth and Bloom on their efforts in their volunteer work with the Verrazzano Garden. Also, as part of working with the larger community, I'm a board member of the Delaware chapter of the American Planning Association, where we do numerous training and networking events throughout the state. I'm also part of a statewide effort working in conjunction with the state chapter of the International City Managers Association, working on developing recommendations on how to increase housing, including affordable housing, throughout the state. Finally, I'm also a current president of the Delaware Women Leading Government, which is a subsidiary of the ICMA, where we conduct trainings and networking opportunities for women who work for and with the public sector. When I was brought on board last year, establishing a code enforcement program was an area of focus. Our approach for our code enforcement team is to be proactive with an emphasis on procedures and documentation and building relationships in the community. We work closely across the organization, especially with the police department and public works. Our code team is now sworn and they have the ability to write citations, which can be appealed to Alderman's Court. The areas we've been focusing on in code enforcement include noise, signage, and business licenses in the commercial district, refuse and yard recycling containers, ensuring safe and accessible sidewalks, as well as enforcing construction hours and rental inspections. For business licenses, we embarked on a data cleanup of business licenses, which included ground truthing of our brick and mortar businesses. Finally, in our current projects, we are working with consultants for strategic solutions on reviewing and assessing the city's permitting, licensing, and application approval processes with the goal to improve workflows and customer service. We are currently working with Strategic Solutions on PDF fillable forms for permit applications and scheduling munis training for staff, as well as implementing workflow steps. The last section, to wrap up, is projects that we'll be working on moving forward. So looking ahead, we're going to be certainly working on continuing improvement on our business license, permit, and plan review process and implementation of the Strategic Solutions workflow and priority actions. I'll be looking at, we'll continue to look at the CDP implementation. I have another slide talking a little bit more about that. Bidding out a landscape and irrigation contract. Now I can hand that off to our arborist. I'm so excited. Getting the new arborist up to speed. We mentioned that earlier. Mixed-use zoning ordinance task force, moving forward with that. Examining and analyzing data. And regarding code enforcement, looking at rentals and doing a deep dive, Commissioner Gossett, doing a deep dive into current rental data and to identify gaps, and analyzing rental code for recommendations of further compliance, as well as doing inspections on permit of compliance and fats, oils, and grease inspections, otherwise known as FOG. So for the comprehensive development plan, as you're aware, there are a number of action items from the comprehensive plan, 88 specifically. Some of them involve the planning community development department, some of them not. But the first order of business I want to start on are the 22 code updates that have been identified. And that's this plan right there. Most of them have to do with the purview of the planning department, some of them not, but I want to review those and get them moving forward to the Board of Commissioners, Mayor and Board of Commissioners. The other code CDP effort that we need to start on for next year that I want to start on in April of 2026 is the 5-year update. The 5-year update for the CDP is due June 28th, 2027. So I believe this effort should be started in April 2026. So finally, my last slide, in addition to the CDP code revisions, there are a number of code updates that the department would like to pursue. I would like to organize and prioritize these potential code updates in addition to the CDP updates that is over here. Prioritize these and then bring them back to the mayor, to you all, to mayor and Board of Commissioners for review, input, and prioritization at a future meeting, not in the too distant future for review. I want to organize them like There are some that are going to be like just quick text amendments, some that might be a longer effort, and with input on how long each might take. And a suggested priority list from our perspective, but certainly want input from you all on what you think the priorities should be, and then we would set about doing them. So that concludes my presentation. I'd like to thank you for your time and attention. I hope you found this to be informative and helpful.
Thank you, Mary Ellen. Are there any further questions up here?
Mary Ellen, could I ask what the current turnaround time is for the issuance of both residential building, new construction building permits, and then just some simple ones like a HVAC replacement, fence,
Sure.
something like that?
Sure. I would say I'm looking at Corey, we're about 2 weeks for new residential building permit. What are we at right now? Well, Corey, answer that question.
If I can, yeah, so for residential on the permits that I do, I'm still currently at 30 days or less. There's occasion where it takes longer, but that's when I have a revise and resubmit.
Okay. So 4 weeks is the average?
Yeah.
Correct.
And for our regular permits, I would say it depends upon the permit, but I would say on average we're about 1 to 2 weeks right now. We did have quite a backlog about 4 months ago, but we are unburied from that backlog, and we are probably about 1 to 2 weeks turnaround time right now.
Thank you.
You're welcome.
Anybody else up here?
Mayor?
Commissioner Good?
A question for you, please, about this 2-foot storefront. Does that refer to the brick below the glass window display at our local, a lot of our boutiques?
Yeah, so and here again, this is certainly up for further discussion. This is not in our code right now. What our code enforcement officers have been noticing is, and enforcing, is that the street, the sidewalk is a right-of-way, and you can't put merchandise out on it. But there is a great desire to put merchandise on the sidewalk. And there are some areas of sidewalk that are wide enough that wouldn't obstruct flow or wouldn't obstruct the sidewalk. So if there is a desire I think might be a desire in the business community to allow a certain amount of merchandise that would be from the wall of the building into the sidewalk to allow the display of merchandise. That's what we're thinking.
2 feet deep, you're saying?
Yes.
Yeah, okay. And my second quick question is that there already does appear to be an ordinance which applies to swimming pools, I believe from 11 p.m. to 9 a.m. I'm not sure that it's enforced all that well, but how this would this be in are you looking, what situations are you planning to cover besides swimming pools?
So in what ordinance are we talking about?
There's a City of Rehoboth Beach brochure which actually says that for, I guess for quality of, I don't know, either quality of life or quiet enjoyment, that swimming pools should not be, there should not be a lot of disturbance around a residential swimming pool between 11 p.m. and 9 a.m.
Right, so that would be a noise complaint, and I believe, I'm looking at my code team here, I would have to look into that. I'm not sure of that code provision. Happy to look into that and get back to you on that.
Thank you.
Anybody else up here?
Mayor, just one question. Thank you for the information. With regards to the strategic solutions, what is the schedule to kind of complete that implementation?
Sure. We are wrapping up, probably within the next couple of months, we're looking to wrap that up. Where we have a preliminary, there's a couple of things going on to wrap it up. First is the scheduling of training. And we have some dates from Tyler that I sent back to Director Hamby on getting our training scheduled. We have an internal meeting scheduled next week to complete our review of the PDF fillable forms for the contractor. And So that would be that phase. And then there's another, so I think then that would bring us up to what we can implement right now until we can get more training on Munis, because there are some other implementation components in Munis, in the implementation that we would need to do. So, I'm sorry, probably the next 2 months. Yes.
And
Sorry, I started rambling. I started going into rabbit hole.
and does part of that plan presented by Strategic Solutions have a metrics for measuring success in this implementation?
Yes, we do have a guide
Okay.
and checklists and yes, all the like, yes.
Commissioner Thea, did you have a question? Did you have a question?
I did not know.
Okay.
Thank you, Mayor.
We'll go to the members of the public. Tom, come ahead.
Good question.
Tom Gaynor, property owner in Rehoboth. So may I look at her without being disrespectful to the board? Because the questions are really to her. First and foremost, thank you for taking down the dead cherry blossom tree at Munson and Bayard. I wish it had been taken down before the season started rather than all during the season, but I'm glad it's gone.
If I could just, with the contract with Save a Tree, they tried to get as many trees as they could get down before the season, but then they paused during the season, and then they completed it after the season. We didn't want them taking down trees during the season because of parking issues and just everyone being here. So, yeah.
Two things related to that. One, given the fact that we have the curtain goes up Memorial Day weekend, the curtain comes down roughly Labor Day weekend. If we could have a concerted effort now that we have a new arborist, that we're ready for game day when the curtain goes up. And if a concerted effort could be there to prune and take care of the dead stuff. There are 3 half-dead ones that need to still come down on Bayard. And the second point along that is I'd like for you and the new arborist to not follow the same path as the prior arborist and commit to preserving Rehoboth's strong legacy of some of the most beautiful trees that exist, that is the cherry blossoms. So please don't litter the symmetry and the beauty of Bayard with any more Chinese redbuds, which was
Chinese redbuds,
was the prior arborist's passion to replace the cherry blossoms with god-awful Chinese redbuds. When you look around at the city in April, this city is a gem because of those cherry blossoms that were planted, some of which were over 100 years old around the Scarborough Park. So let's focus on maintaining and preserving part of the city's legacy. And the other thing is there are a bunch of dead things that probably should come out of the park where the kids park by Bad Hair Day.
Oh yeah, I was just by there yesterday, Tom. Yeah, I noticed that. That's got to come out. Yeah,
and
I was just yesterday. Yeah,
you'd have a great ally, as well as other folks in the room in trying to preserve the cherry blossom, legacy and heritage in the city. So I'd love to talk to you about that offline at some point. So thank you.
Thanks, appreciate that. Hi, I actually have it's Susan Gay again, this time as city resident. I have a couple of comments, and I have her slides here on my phone. Since I'm supposed to be talking to you, I didn't want to ask her to go back. But I have a couple of comments specifically related to population, housing, and rental licenses. And I have to say, first of all, everybody who knows me knows I love data. And this is data that I've been looking at ever since I was first involved in working on the CDP about 6 years ago. It's very difficult for a community like ours to get accurate data. We have to massage the data we get, because from the Census Bureau and from the American Community Survey, they only classify housing in 2 ways, occupied or vacant, quote unquote vacant. But if you go down on the characterization, actually it's the housing occupancy slide, not the population slide, so it's the next one.
There you go.
So if you go down under vacancy, there is a category for seasonal, recreational, or occasional use. That's where you get the 92.9%. However, those are not available for seasonal rent, all of them. I mean, my house is in that. It's not available for seasonal rent. There are many other houses that are not available for seasonal rent, but they are occupied, not necessarily even seasonally, but again, like me, every week, every other week, throughout the year. That's why it's so hard to get a handle on what our true population is, but the real numbers affect the services we use, the services we need and all that. I think it's fascinating. I also think there's probably never going to be a clear answer. But, so in addition to that, in addition to probably not having anywhere near 92% available for seasonal rent, there's a disconnect, as I think Commissioner Gossett noted, between those units and the number of rental licenses. And in the 10 years I've been around, it's been fairly consistent that it's about, and I'm looking at houses here because I know that the percentages are much higher in places like Star of the Sea and the Henlopen. But in single-family houses, I've always been under the impression the number's about 30%. And so that says to me, it should say to all of us, that it's not really a rental community if 70% is occupied either by full-time residents or part-time residents like me. That's an important data point. But the other thing is, on the rental licenses, there is software out there. We've talked about this for years. When I was on the commission, I recommended it, and when Sharon Lynn was here, she didn't think we needed the software because we had people in-house that were going online to sources like Airbnb and verifying who had licenses. But it may have gotten beyond us. And I know that a couple of years ago, Dewey spent $14,000 to get the software, and it has paid off handsomely to generate more revenue. And I would just suggest that we look into those automated ways for enforcement on rental licenses. That's it. Hey, I made it under the deadline.
If I may, Mayor, regarding those comments, may I? Okay. So two things. Susan, you're absolutely right regarding the ACS data and the categories that were kind of get shoved in. And certainly I would like to try to parse that out. I was starting to talk with Director Hamby on how we can parse this housing occupancy data a little more using some other data sources besides the ACS data. So that's where we were talking about that the other day. And regarding the outside sources, we've gotten, I don't know, we get calls like, we've gotten many calls from many agency or consultants and some presentations, and I think they have a lot of value. What we want to look at first before we look to engage or ask the city to engage a firm to do that, to help us identify rentals in the community, we want to undertake the effort first to see what we can find out, and to see, doing a deeper dive between Amanda, Scott, and myself to see what we can find out using our current data sources and some other non-conventional data sources to see where we are, to take this year and see where we are and see what we can find out. And then if we get stumped, then look to see whether we need to bring in a third party to help us out with that. So that's what we would like to spend this year, next year doing.
Thank you. Thank you, Mary Ellen.
You're welcome.
Next thing on the agenda
Mayor,
is...
one quick question. Do you
Commissioner.
have data on commercial properties that are vacant?
No, not at the moment, and that's another data point I was talking with Director Hamby about, that I would like to get a better handle, and as well as staff, on our commercial properties, on vacancy rates and age of the commercial, because we have somewhat of a handle on our age of our residential, but we don't have much of a handle on our commercial real estate, and I would like to see what we can come up with on that.
You have just a rough timeline around when you'd like to do that?
So I would like to start doing that now over the next year, is start to look at utilizing our current data sources and just see what we can find out.
Thank you.
You're welcome. Thank you, Mary Ellen. With that, next item of business is board and commission reports. We did receive a Board of Adjustment report. I think you all have that printed out, hard copy. It will be embedded into the agenda sometime on Monday. With that, there were no committee reports. Next on the item is community partner reports. We did stop having a in-person representative here to save time. Instead, you'll see support documents for each group that's submitted. I just would like to acknowledge and thank each one of them for participating in that, and just give a little preview of a couple things on here. Cape and Lopin Senior Center, they, among other things, they'll offer a free tour if you go by there. They'll take you through the building. They also have a bi-monthly newsletter. The Chamber of Commerce submitted, and they've got accommodation occupancy report that you'll find interesting. And they also have a reminder that the Sea Witch Festival will take place October 25th to 27th. Rehoboth Beach Main Street, hi Dick, I see you're here, submitted a report, and I think everything's important, but the two things that caught my eye were Wreaths Across America, December 14th, and the 30th Annual Community Unity Dinner, Sunday, December 8th. And very important for pet lovers, the Rehoboth Beach Library tomorrow, October 19th, will have senior cats and kittens available for adoption. So run by there. So again, thank you to those agencies for doing that. Our next item of business in sequence here is public hearing on the subject of amending the municipal code sections 270-4 and 270-39 relating to the definition of trailer and the parking, storing, and leaving of trailers. Just a reminder, because this is amendment to Chapter 270, our zoning code, it requires a public hearing. If you recall, at the beginning of the meeting, I indicated we were going to cluster the two trailer topics. So we've got new business C is discussed Chapter 92, Section 38, titled Parking Restricted for Certain Vehicles related to the parking, storing, or leaving of vehicles and trailers. I think this was to accommodate Commissioners Chernowski and Don Preston that wanted to be able to talk about what was already passed at a previous meeting. So anyhow, I read those together again so that we can have the opportunity to chat about those, and we might want to do the public hearing second. But I understand you're going to give a overview on it, and I don't know if that will include a mention of why we're not enforcing it now and the need for adoption of this new proposal. Thank you. Go ahead.
Thank you, Mayor. Good afternoon. So recall back in August at the regular meeting, an ordinance was adopted to amend Chapter 92 relating to trailers. There were restrictions placed, and one of those restrictions was restrictions on the placement of trailers on private property. And for that reason, I included a companion ordinance to amend Chapter 270 in discussion with Chief Banks, and Building and Licensing. It made sense to also include provisions in the zoning code since we're dealing with private property rights here. I'm happy to go through any provisions you'd like me to discuss in depth, but I'm sure you've all seen the ordinance that was adopted in August, and I'm happy to answer any questions you have.
Alex, is it appropriate for a point of information?
The mayor stepped out. I'm not sure what his intent is for including public comment as Vice President. Yeah. Yeah. Could you come to the microphone, please?
Tom Gaynor, property owner in Rehoboth. Are you saying that what was passed on August 16th was improperly passed?
No, that's not what I'm saying. I'm saying that I also included an ordinance to amend Chapter 270, which requires a public hearing, and that's why we're here today for the 270 piece, because I wanted to make sure both chapters spoke together and there was harmony and there's clarity about how this is all going to work.
So what was passed in August 16th, that, as the mayor identified, it was rushed, ill-thought, and improperly timed, was properly passed, but is not being enforced. And why is it not being enforced if it was properly passed?
Yeah, so to answer that question, it made more sense to wait and get it 100% all in the books together in conversations with the city manager and chief of police. Having it all together, having a comprehensive plan moving forward made sense.
So it, in fact, turns out it was sloppy and ill thought out, as the mayor indicated. Okay, thank you.
I have a clarification point too, since there was one already made. Right, so Lisa Schlosser, Dover Street. The point was that of talking about this as well as the new definitions was to do it together to make sure that the definitions define the scope of an ordinance that was already passed, which doesn't make any sense to me, but that's beside the point. So the point of bringing this ordinance that was passed on August 16th up at this meeting was so that we could talk about the definitions and the new ordinance together. So I'm wondering why we can't just bring the discussion on both the definitions, I think it's new business item C or something, and the public hearing information. Why not talk about it together, because they're absolutely related and dependent upon one another. So I don't know why we're separating the discussion. Thank you.
So Mayor, you were out, there were two.
Your name.
Harvey Shulman, property owner. There were two speakers. I know the time has not been running on anybody, so, and I'm sure there will be a time when we speak again, you'll say that. But it's just a couple of points in response to what's said. There's really a lot of confusion about this issue, and part of it is because it's not that complicated, but you have to distinguish the zoning code from the parking code. Okay, there are a lot of things in the city code that do affect private property, but are not in the zoning code. An example is trees. It's hard to imagine what you can tell a property owner he or she can't do with their property that's more inherent in the property than a tree, but it's not in the zoning code. And I could go through other sections of the city code. So the fact that something is not in the zoning code doesn't mean it's not valid, it's not enforceable, etc. The other point I want to make is that the city solicitor said, and I agree with this and understand it, there is something to do with trailers in the zoning code. Okay, so it is best that they kind of have the same definition, if you will. Until a year ago, when the planning director issued a ruling about what trailers are prohibited by the zoning code, I can tell you, and you know this, this was not an issue for 30 or 40 years. But what's gotten us where we are today is that even though the zoning code, and this is important, the zoning code already says it's trailers are not permitted on private property. Okay, there's some exceptions. But the interpretation that was issued said only house trailers. Now we all know trailers are horse trailers, office trailers, house trailers, boat trailers. But the interpretation, which came out of nowhere, said the zoning code, when it says trailers in that section, only means house trailers. So that's how we got to today. I'm not arguing, one way or another. There'll be time for that when you ask for comments. I just want to make clear that the reason we're at this definition of what's a trailer in the zoning code is, and I agree with the city solicitor, it's best to have a an inclusive definition, but it was never unclear to anybody, and the state law says trailer. Now he wants to put in trailer means any kind of non-motorized vehicle that can be hauled across the road, including house trailers, horse trailers, office trailers. So please keep that in mind, okay? That today, and Ms. Schlosser said, there are really two issues. The parking ordinance was done in August. The effort now is to address the zoning code and the lack of clarity that was created a year ago. Thank you very much.
Thank you, Harvey. Gentlemen, did you get your points in? Because we put this one thing in the agenda specifically for you all. That's 15C, discuss chapter 38, titled parking restricted.
I mean, I asked for it to come in because they're interrelated.
While I was going, Patrick, did you open the public hearing, or?
I did not. We had speakers already.
Relative to the public hearing on the subject of amending 270-4 and 270-39 relating to the definition of trailer and parking, storing, and leaving of trailers on private property, are there any more comments? Now, we only allow one time.
Yeah, my comment prior was a point of information to Alex, asking why, if the ordinance was legitimately passed, and to use your words, it was rushed, ill thought out, and inappropriate, why was it not being enforced? And then Alex explained that there are inconsistencies in the code, which in my opinion reinforced your initial gut instinct, which I think was spot on, that this thing was a farce from the get-go. There was also an ethical accusation at the end of that meeting from Commissioner Preston against the vice mayor, and part of that was, I think, dispositive on how the rushed aspect of that came about. Did anything come from that accusation? The emails that I think were brought up at the end of that meeting were accusing you of improper abuse of your position?
So I just want to clarify that my comments weren't directed at a person. My comments were directed at all of us. If any of us were to attempt to use our seat to attack a single person or a neighbor, or we shouldn't be doing that. It wasn't directed specifically at anyone on the commission.
Well, there was a specific reference to emails in your possession at the end of that meeting.
Sure.
That caused Commissioner Gossett to leave.
I don't know if he left, but it doesn't matter to me.
And I guess
the point is only to say
the public wished that those emails would have come out during the discussion.
Sure.
Because I think they were dispositive on the fact that it
sure,
was
but they
rushed,
weren't
it
official.
was sloppy.
If they had been official on official city email, they weren't.
Okay.
But
that's fair. But you brought them up in the context of a meeting, Don.
I did.
And the aspect of the issue that was dispositive is that the trailer that was in question, there's really like one that was targeted. And
well, there may be
kinda
two.
makes
There may be two.
Well, one that really was really the issue on Henlipin Avenue, and the other one that's
Correct.
fairly close to a residential property occupied by another commissioner. So this whole thing kind of stinks to high heaven, and it's kind of just left a bad taste in everybody's mouth. And you guys could really do a better job at this by not rushing sloppy legislation that attacks two individuals in this city. And it was inappropriate. It's still inappropriate, and I wish you guys would back down from it.
Well, I don't know that I stepped out a minute. I don't know that we officially opened the public hearing on this topic, but I think we can record everybody's comments up to now and make sure they're part of the record. Additionally, Matt?
Thank you, Commissioners. Matt Gaffney, 140 Henlopen Avenue. I don't really think it stinks, and I don't really like that terminology. I don't think it's in the spirit of what you all are trying to do here. As has already been said by Harvey, this is really not a new conversation. This is not a new concept to come before the commissioners because it's already been in the books for years. Section 27039C says that trailers, mobile homes, or relocatable homes shall not be stored or placed upon any property in the city without a special exception granted by the Board of Adjustment. And in granting such an exception, the Board of Adjustment is going to look at the character of the neighborhood in determining whether it's appropriate or not for that trailer to be there. If you read through the comprehensive plan, which I did this morning, and you look at how we define the character of Rehoboth, trailers on private property, in my opinion, are not consistent with the spirit of the comprehensive plan in terms of what we want our neighborhoods to look like. So I support what you've done. I support what Alex Burns has put forward in regard to a parallel effort in the zoning code. The language I just read is already in the zoning code. We're not creating this out of thin air. This has been part of our code. We are merely trying to define how and what a trailer is. Trailer is already defined in section 92(1) under definition. So again, we have discussed what a trailer is. It is in the code. You are merely trying to clarify that for the zoning portion of the code. And when this was passed a couple months ago, I did go to City Manager and Chief Burns wanting to know why they were not enforcing it. And I was told because it isn't represented yet in the zoning code. So that's the reason why we're all here today. So I don't think we should mischaracterize any of this as nefarious or bogus or whatever. I disagree with that. Thank you.
Thank you, Ned. Anybody else? This is a public hearing. Andrew?
Yes. Are we commenting on the public hearing? I'm not clear.
We're commenting on the public hearing, yes.
Okay, I didn't know that, so I have other comments.
My name's Andrew Tylecki. I live at 233 Rehoboth Avenue. And this trailer ordinance is going to drastically affect me. I have a trailer in my yard. It is not a mobile home. It is a box trailer for carrying my car. Now, my occupation in life is I restore cars. It's a hobby. You're taking away my lifeline right now that I can't do. And I don't understand why we need this legislation. And if, as Mr. Gaynor said, if it's a result of just two people complaining, the other 1,300 or 1,500 of us don't need to be, we don't need to be held and responsible for someone else's actions. I just don't think it's correct. And there's a lot of other things in the city that need to be addressed. And I'm going to bring up the thing about the trailer on the boardwalk too. Because if you pass this ordinance, whether you pass it or not, that trailer will come off the boardwalk because it's a construction trailer. And there are some other trailers in town right now that probably shouldn't be here by your ordinance. But you're taking away my personal freedoms if you pass this ordinance. That's all I got to say. If you got any questions?
No, thank you, Andrew.
You're welcome.
I have a question on the ordinance since we're in public hearing now, so, or a couple comments. Lisa Schlosser, Dover Street. I just want to remind everybody who hasn't been following this issue, this ordinance, as mentioned before, discussing other ordinances and the need for speed, why, but anyway, this ordinance was previewed on August 5th. It was passed 11 days later. This is like record speed for passing an ordinance in this city, by the way, on August 16th in the dead of summer when most of us were traveling. So I have several other questions. It seems there was no data prepared other than some comments from folks on Henlopen Avenue about one trailer. So I have questions. I don't think there's answers to them, but I'll try. And Commissioner Gossett, they're to you because you prepared this ordinance. So how many trailers are there in town?
Lisa,
two.
Recognize this is a public hearing, and it's really to receive comment.
Yep, that's fine. I think you don't have the answers anyway. That's why you're not answering. So how many trailers are in town? How many camping trailers? One, mine. How many garages do we have in town? Since you said in this code or this revised code,
or zoning ordinance that there's so many exceptions. Well, how many parking garages are actually in town that would allow for the exception? I don't think anybody knows that answer too. And the main point is this. The right question to ask for the new commissioners particularly is, do you want to be a board of commissioners that regulates everything on a private property? Is that your job? No. The charter said that your job is to make sure that the public safety, health, or welfare, not the interpretation of the code of the CDP from one person in town, that's not your job. Your job is public safety, health, or welfare, to write ordinances. So that's the question I ask, particularly you new commissioners. Do you want to be a homeowners association? If so, go start a homeowners association. But the Board of Commissioners' job is to ensure public safety, health, or welfare. Determining what I put as a constitutional right on my private property is not within your jurisdiction, and it's violating my personal property rights. Besides the fact that this is a sloppy, it passed in 11 days, I really think you need to not vote on this zoning change, and you need to make some revisions to the past ordinance, such as you may park a trailer on an approved private driveway, or the driveway's documented in the property survey. That's a kind of thing you could do to accommodate this other fellow that just spoke, as well as people like me who have the one camping trailer that's being targeted here. Thank you.
Thank you. Thank you, Lisa. Anybody else? Or is it one time each? One time each, Ned. Thank you.
Excuse me? I'm sorry, Mayor.
Have you, everybody gets one shot.
Well, the two prior speakers spoke previously, as did I, so if we're going to have a rule for one time, but they were given 3 minutes during the hearing, I would ask the same courtesy. Thank you. I want to come back to...
In the order of fairness, if we allow somebody to go twice, then everybody should.
Thank you.
Lisa and I both asked 1 minute questions of the lawyer, that's all.
Okay.
They were there more than a minute.
We weren't there for 1 minute.
Mayor, may I? Thank you. May I, Mayor? Thank you.
Oh, yeah.
I want to come back to what I said previously. This is a hearing on the zoning ordinance. This allows you to clarify the definition of trailer in the zoning ordinance. I don't know how anybody could be against the definition of better defining trailer in the zoning ordinance. It's there. So you're only helping people understand what it is. I don't think it's necessary, but it's useful. Secondly, thank you to whoever put together in the package that was posted about coastal Delaware trailers. Because, pardon me?
Commissioner Bennett did that.
I'm sorry?
Commissioner Bennett did that, and Patrick provided it.
Well, if you look at that, you will see that Rehoboth Beach is right in the middle. It's not the most restrictive, and it's not the least restrictive. All these other towns in here, some of them absolutely prohibit trailers on private property. There are no exceptions. You adopted 5 or 6 exceptions. Construction, you know, on and on. I won't repeat them, but they're in the ordinance. It's pretty generous. A lot of towns don't have that. And let me just say, if people are concerned about public health, safety, and welfare, please keep in mind, a lot of the towns that do allow trailers on private property under their zoning codes actually say not in the front setback area. Okay? They can't be used for an office. I'm not talking about living in it. That's a habitable thing. This doesn't apply to RVs because RVs are not trailers. RVs are motorized vehicles. So please look at what you've done here. It's pretty narrow and restricted to what's being prohibited. Construction trailers, yes, but there's an out. You have an exception for construction trailers. And it can even go longer than you've already provided. If the construction lasts a long time, they have an ability to go and get a longer permission from the Board of Adjustment for that. And I also want to talk about dumpsters. This does not apply to dumpsters, construction dumpsters. There are a lot of people who have criticized what you did in August as not going far enough. Someone can have a dumpster. A dumpster is not a trailer, and nobody will disagree with that. So this doesn't interfere with construction where somebody puts a dumpster on their property. I ask you, when you please, please, let's come back to what this is. It's an effort to define trailer in the zoning code in a way that is very helpful to everyone and gets us away from the decision that was issued a year ago out of the blue, which somehow narrowed the definition of trailer and would never hold up in court, by the way. Thank you, Mayor.
Thank you. Anybody else? Matt, did I call you Ned earlier?
Might have, that's okay. Matt Gaffney, 140. This will be very quick. Lisa, you're my friend. I respect your property rights. But this is a community. We live on 50 by 100-foot lots. We live on 50 by 100-foot lots, most of us. Do we really want to look out a kitchen window or living room window and 8 feet across is somebody's camping trailer? I don't want to live that way. I don't think it's appropriate. We should be talking about we more than we talk about me. Thank you.
I want another minute.
You got
Harvey had 6 minutes. Tom Gaynor, property owner of Rehoboth, that's ridiculous. You're talking about an aesthetic preference governed by a state body. The state's role is not to sit here and accommodate your personal preference of what you look out your kitchen window. That is an abuse of your authority. You don't have the right to do it, and you infringe on other people's property rights. And you want to talk about me versus I? If there's anything that is more egocentric and arrogant and condescending, it's I don't have to look out my kitchen window and see somebody else's ugly, licensed vehicle that's legal in the state of Delaware. I can't imagine actually standing up here and telling you people that. It's respect people's rights, respect your authority and the limits thereon. This legislation does not do it.
Thank you, Tom. Anybody else? No.
Mayor,
no,
that was his
no,
third.
no.
Are you denying me the same opportunity as another speaker?
Yes, yes.
Okay, I'd like the record to show that you allowed one speaker to address you 3 times and you denied me the right. That is not consistent. And we have, Mayor, we have people from the audience speaking up. That's not appropriate. I want the record to reflect that.
I'll take it back.
Because that is not consistent with state FOIL requirements.
I'll give you 1 minute.
Thank you so
And
much.
that's it. And that, if anybody else wants to speak, I want to see your hands now. You get to speak. And Walter, you want to speak? 1 minute.
Okay.
I
I want to come back to the.
allow one time.
I want to come
one
back to
shot
the
per
same
minute.
point. The code, the zoning code now says no trailers on private property. This is an effort to define that in a way that's clear. You're not expanding it. You're not eliminating dumpsters. All you're doing is defining something that probably doesn't need definition, but it's helpful to people, okay? As far as constitutional rights go, you know, we live in an age where everybody believes they have a constitutional right to anything. I come back to trees, you know, you have restrictions on what animals could be kept in houses. You know, we can go on and on and on. So let's get away from the Constitution and deal with. Mayor, you made a comment earlier about people being disrespectful, and I personally don't appreciate it, standing up here and someone in the audience laughing and nobody in the dais saying that's disrespectful. That's a problem.
I agree.
I want to hear what
And
you have to say.
nobody has asked the person who did that not to continue with that kind of conduct. I thought we were moving to a new era here where people could be respectful to each other. And to stand up here and address you and have someone out there laugh and nobody here say anything is not very conducive to getting people to come up here and speak.
You're right. Thank you, Harvey.
Mayor, he's right, and, you know, this is, I think, now probably the second time I've addressed this. You know, Commissioner Preston and I went back and forth on this earlier, but he's right. You made a statement at the beginning of this meeting, some people clapped, that you're gonna keep things under control.
I said he's right. What more do you
But
want?
he's right, but he's right is just, I mean, that's just not good enough, right? You have to, it's not good enough. I'm not gonna tell you what is or is not good enough, but that's simply just not good enough.
No.
I apologize for lacking it. Let's get away from the constitution. I withdraw the black.
Walter, let's start you off with 3 minutes, please.
Walter Birmingham, 123 Henlopen Avenue. I'm not sure the Attorney General's office would go by your rule decision on the fly that you can only speak once. Sometimes you don't know what other people say. You don't know what you're going to say till you hear other people. I'm not talking to the subject of trailer. I'm talking to, that's what's wrong here. You hear what you want to hear, but it's a hearing ought to be open so you get all the facts, and you're not handling that well.
Walter, respectfully, this is a public hearing. The
That's why
topic is
that's why I'm telling you,
trailers.
because you're not doing a good job with it.
Yes, ma'am.
Good afternoon. Celia Garrity, homeowner, year-round resident, pariah of Henlopen Avenue with the trailer. I have pretty much given up any hope that the ordinance won't go through. The state does give towns the authority to regulate such things. You know, the fact that I have no place to put it, I haven't been able to sell it. I'm actually currently using it as a construction trailer off and on. Seems to be irrelevant to the aesthetic view of the townships. You know, so pass the damn thing and move it on, and if somebody decides to sue y'all on how it was handled, so be it. It won't be me, because it's not worth the time and effort and moments out of my life to fight with this anymore. I mean, it's just ridiculous. But like I said in the last meeting, you never know what kind of truck I might buy.
Thank you. Last call, this is a public hearing. Does anybody want to speak in favor or against the ordinance? If not, then we're going to close the public hearing. Thank you. We bring it back to the
Mayor,
commissioners.
I have a question.
Commissioner Preston?
In our last meeting, I asked if someone would reach out to Summer House to let them know that this would significantly impact their refrigeration trailers. Did the staff do that?
So we have been in discussions with them on their renovation that they're doing back there, but specifically about the refrigeration trailer, no.
Thank you.
Public hearing's closed, Walter. Public hearing is closed, Walter. Anybody else have any comments up here or discussion, or I'll entertain a motion?
Mayor, I'd like to make a motion to adopt ordinance amending Chapter 270, Section 4 and 39 of the Code of the City of Rehoboth Beach relating to the definition of trailer and the parking, storing, and leaving of trailers on private property.
Is there a second?
Second.
Who seconded it? Bunky. We have a motion made by Commissioner Patrick Gossett and a second by Commissioner Bunky Markert to adopt the ordinance before us, amending Chapter 270, Section 4 and Section 39 of the code relating to the definition of trailer and the parking, storing, and leaving of trailers on private property. Is there any further discussion? I'm going to do a roll call vote. I want to remind everybody that because this is in the zoning code, you need to give, after you give your vote, give a rationale and tell us why you voted that way. We'll start on my left. Commissioner Suzanne Good?
I need to vote nay because we've taken care of the safety considerations, which put sometimes pedestrians and joggers at risk on the city's streets and rights of way. And we live in a town where most of the lots are 5,000 square feet. We're not subject to a homeowners association. I think the exception might be country club estates, which could start enforcing exactly what sculptures, trailers, and everything else people choose to have on their land. So at this point, I think a little bit like someone like Judge Judy might say, there needs to be some agreement reached between the 149A trailer and the immediate neighbors. Probably money will, it's always down to money to grease the wheels to have that trailer stored wherever in a storage facility, because that might solve the problem, wouldn't take away the rights of 2,000 other property owners to have such to have an item in their on their property. Thank you very much.
Commissioner Preston?
I vote no. As a board, the board has taken a view over the years, over the decades, to not do exactly what we're doing today, or some are hoping we'll do today. And until we have a more holistic discussion about, are we going to regulate the aesthetics of our town, which we don't do today, I can't support this.
Commissioner Sernowski?
I vote no for the reasons that Commissioner Good and Commissioner Preston mentioned. And further, I don't think we should be in the business of regulating people's private property rights, nor should we legislate based on aesthetics. So I vote no. Thank you.
Commissioner Gossett?
I vote aye, based on the fact that the prohibition of trailer parking is already in the code. This is better to define the trailer in the zoning code to provide the ability for the enforcement of 9238.
Commissioner Markert?
I vote aye. I feel that this does fall under the, I guess, definition of welfare, and that welfare has to do with how we deal with each other as a community. And I would like to think that a town as prosperous and as considerate and generous as it is to its people, under most circumstances, that we can't get sort of a minimum level of acceptability in how we behave. And I just felt like this was, as one example, not a pivotal example, but an example of a minimum qualification that we can all agree on. And that's what I agree on, and that's why I'm voting aye. And I would hope the remaining commissioners will feel the same.
Commissioner Thayer?
Yeah, I'm gonna vote aye. I guess I have to explain myself, right?
It's permissible to say for the reasons stated, so.
Yeah, so I'm going to vote aye. This is, I think this is a community where imagine that, me, a lack of words. But I'm going to vote aye. I believe that it brings us consistency amongst the codes and ordinances that are already out there, and it just provides additional clarification to what already exists.
Thank you.
Thank you. And I essentially look at the code already being passed last time. As you know, I voted against it. However, at this point, at this moment, I consider that law passed, and that this is needed to be able to enforce that law. Now, I believe that we did rush it last time, as I said before. I believe that it should have had this companion law at the very same time, because we might have had a different outcome that allowed more things and didn't allow certain things. But again, because it's already passed and this is a companion, the chair votes aye also, and for the reasons stated by my colleagues on the right. Therefore, it's a 4-3 vote, and the motion does carry. With that, our next bit of business. We're doing, because of time constraints, we're going to jettison item 14D, that's about basements. In lieu of that, or we will continue with new business A, presentation by code enforcement on enforcement efforts related to non-habitable basements.
And can you change the computer again for their presentation? Thank you.
Good afternoon, Mayor and City Commissioners. My name is Amanda Pombo. I'm one of the 2 code enforcement officers here, along with my partner, Scott Cantalupo. This is about the unlawful conversions and enforcing the codes in non-habitable basements. The introduction, key questions. What is the main issue? Homeowners are converting their non-habitable basement space into habitable areas against the city code rules regarding allowable uses. How prevalent is such use? Is this a true concern? Are people breaking the occupancy rules? What is the current enforcement pathway? What, if anything, can code enforcement do to discover and stop such unlawful uses? The approach to our investigation was we collected details on recently built homes. Of those, we can only investigate those that were licensed to rent. The information collected through internal and open source searches of all newly built rental properties, we were able to discover on many homes containing non-habitable basements used for habitation listed for sale or rent. The basement totals from May of 2018 through September of 2024, there were 147 total new homes built. 36 of those homes hold rental licenses. The new homes with 6-foot by 6-inch basements is 93, which equals 63%. The unlawful basements we found after online searches was 12. Those were properties listed for sale or for rent. 9 of the most recent 32 homes built are licensed rentals. Now, what can code enforcement do? We can request an inspection of a rental through the city manager per City Code 210-8C, which gives the homeowner 21 days to respond and allow access to inspect. We see unlawful use and instruct that it must be converted back to storage. We have a follow-up inspection scheduled to verify remediation if we did locate the fact that they did convert it into habitation. Suspension or removal of the rental license per City Code 210-6 If an owner refused access to inspect or otherwise refuses to remediate, code enforcement can request suspension or revocation of the rental license and cite for renting without a license if the rentals continue. Why is this a concern for the city beyond zoning issues? It's a life safety concern. It's a FAR density violation per City Code 270-21B, and it's an overnight occupancy violation per City Code 210-7D. Is this really a problem? And we went online and found all of these articles. Fatal fires since 2016. This community was cracking down on illegal basement apartments. Landlords are urged to register their dwelling after 2 people have died in 32 fires that have occurred in illegal basement apartments. 3 boys killed in a fire were trapped in a legal basement apartment with only 1 exit blocked by flames. 4-year-old boy was killed and 3 other children are in critical condition as a fire broke out. Violations were issued to the homeowner of a Bronx home where a 5-year-old boy died in a fire. The child was found in the basement on a bed. It was a hard stretch. There were tight quarters, said the chief. Here's where some property owners were found guilty of manslaughter in fatal fires involving non-habitable, unlawfully converted basements. And it just goes on. You can read the headings. Man found dead in a legal cellar apartment in New York. Jury awards $1.6 million to parents of a 24-year-old woman killed in a fire at an illegal Toronto rooming house. And she died in a basement apartment. Here's where 5 people died in a house fire in a basement. The cause was accidental smoking, and the people ranged in age from 16 to 23, and they died from smoke and soot inhalation. Here's another one in New York. 16 people reside inside the illegal rental property that became a death trap for the 81-year-old tenant who was living in the basement where the fire started. 16-year-old found dead in the basement during a power outage in Michigan. 12-year-old girl dies after being trapped in a basement during a Montreal house fire. And here's somewhere you can see landlords being fined for fatal basement fires. Here's one where a fire chief said that they're finding illegal, unsafe apartments at every response. That's just a culmination of all of the articles that I just went through. So what do our inspections show us? If you look to the left and the top right, those are what we find online. To the bottom left and to the bottom right is what it looks like when we go in to do the inspection. And I'm sure as soon as our inspection is completed, it reverts right back to those 2 top pictures. So unfortunately, code enforcement is not the solution to this problem. All that can be done now is that we can discover or suspect an issue, work through the city manager to gain access, order remediation, then hope that the condition does not return. And this is only for rentals, where we have had a reasonable opportunity to discover the violation. There needs to be another method in place to prevent these unlawful uses from taking place. If we continue allowing these basements to be finished, it is obvious that they will continue to be used as an unsafe and unlawfully habitable spaces. And something that I had found after we had already completed this presentation, one of the most recent inspections I went on, and I wasn't able to embed it into this, but on the wall of a basement that had 3 bedrooms in it, the sign on the wall said, "This area is for children only due to the city code/ordinance," on the wall of the basement. In their own descriptions online, when we were able to find them, I found things written in there like, lower level of the home has a large bedroom/play area with 4 twin beds. This is perfect sleeping accommodations for kids. And then in parentheses, the ceiling height is low. Another one, also there's a den on the basement level with TV and ping pong table. In parentheses, low basement ceilings. Here's another one, head down to the basement with 6-foot ceilings for a great open space with seating. A TV, game table, bar, and foosball are available to guests. It's a great area to hang out and enjoy the family. And it just goes on the way they tell me they have full basements. Oh, this one said, the basement is a vacation dream, featuring comfy seating for 9, a huge wall-mounted TV, pool table, and skee ball. Changing policy is the solution. Changing the policy would indeed be a more effective solution for addressing unlawful habitable basements. Code enforcement can only operate within the existing legal framework. So if the policy itself is inadequate or outdated, it limits the ability to properly enforce violations. By updating the policies, the city could establish clearer, stricter guidelines, ensuring that enforcement aligns with safety standards and regulations. That's it. Does anyone have any questions?
Thank you very much. I think my quick conclusion is that there is no 100% effective thing that we can do to prevent illegal basements, conversions. Even you mentioned, Amanda, that some of the basements there that are housing people and children are 5 foot high or something. So what it tells me is that we can make all these changes that we've talked about, but it's still no magic wand that's going to cure it. So I don't know the solution. That doesn't mean we don't do anything. I think that we try to amend the code and the heights and do their best to try to deter. And I think that's the best we can do.
Mayor, question if I could, please.
Commissioner Thayer.
Yeah, thank you. I know, and again, she's talking about, her presentation is on uninhabitable basements. I'm going to ask a question about basements because some of the previous discussions, which I wasn't involved in as commissioner, included, well, we'll go back to just basements, right? The issue is, to me, is, we're talking about life safety, it's egress, right? Houses are built with one egress into the basement. If we say, okay, we're going to allow basements, we're going to go back and say, hey, we're going to have basements, you can build it out. Don't we have the same problem that it's one egress and it's a life safety issue?
Yeah. So what's the solution? If you allow a basement, require 2 egress windows or something? I don't know.
Mayor?
I think we do that now. We require an egress window in a basement.
Yes, but they're being sectioned off, so if you're in a room where the door is shut, some of those rooms do not have egress. So if you're in a room in the basement, the door gets shut, you're in a room that does not have an egress window. Or for some of them that I've located, especially for ones that were for children, the egress windows were entirely too high for a child to reach and to get out, especially if they're confused and there's smoke and, that disorients you when you're ingesting smoke at the time as well.
And Commissioner, for just a little bit more background, we were planning on pairing this with the actual basement discussion this evening, and while we're not going to have that discussion, I did receive several questions from commissioners just about our efforts in general related to contacting folks about their rental properties that are advertising these non-habitable basements. So that's one of the reasons that we brought this today.
Mayor?
Commissioner Good?
I had thank you for the information. I know that you presented a lot of, alarming house fires, but I wonder how many of those residences had any working smoke detectors. And normally in conjunction with a rental license, I assume you're pretty diligent about checking for smoke detectors. That would be correct?
Not normally in the basements, but yes, every single bedroom has to have a smoke detector, all egress, the hallways going out, things of that nature, but not necessarily because the basements are not considered to be habitable, especially if they're not 7-foot ceilings. then they wouldn't be required for a
Well,
rental
why-
license
yeah.
because they wouldn't be getting permitted to
Right.
habit that space.
My concern is people who obtain rental licenses where the basement looked finished at the time of the initial rental license approval. And whether, when you're doing these inspections, you're sure that the basement wasn't finished when the rental license was granted. And because we're probably about to change the rules as to how much, in terms of we're going to count the finished basement space in the FAR to allow people to have finished basements, I'm worried it's a little harsh on those people who built houses prior to, it might be early 2025 by the time these new rules go into effect. So have you given any thought to grandfathering in people who obtained a rental license when the evidence at the time was that the basement was finished? Maybe the inspector overlooked the lack of a smoke detector down there, overlooked the finished aspects of it.
The building inspector was supposed to come in after this, and he was going to handle more of the zoning questions, but it's my understanding that the floors are able to be finished, even though they're not habitable as the code reads now, and the walls are able to have drywall on them. But they are told when they sign their certificate of occupancy, and I have the certificate of occupancies, it specifically states the basement is not to be used as habitable space.
Mayor, I continue to struggle with this. Commissioner Thier brought up something that I've raised a couple of times about egress. I think it's an important piece of this puzzle. For the life of me, I don't understand how a 7-foot ceiling makes it any safer than a 6'8" ceiling. If there's no way to get out, there's no way to get out. And unfortunately, in a previous discussion about this, a commissioner said that our real attempt here is to control density. If that's the case, then this is a dishonest discussion that we're having.
I don't remember that, no.
Well, you can go back and listen to the record. And we shouldn't be having dishonest discussions. So, again, I think a solution to this is egress. And that's the way we ought to go.
Well, remember, we did defer on the one agenda item, so we will be coming back to this, and at least we have an introduction to Amanda's slideshow here.
And Mayor, I'm sorry, Mayor?
Commissioner Thier.
Thank you. Just want to make sure I'm understanding the purpose of this agenda item. It's just informative? We're not
That's
taking
correct.
any votes
That's correct.
or taking any actions? Okay. Okay, all right. Yeah. Again, I appreciate the clarification. Thank you.
Anybody else? Any members of the public? You have one shot, 3 minutes. One.
Be nice.
Carolyn, who raised their hands back there? Carolyn, you'll be second. On deck.
I don't want to step on toes. Honestly, I don't. Okay, Celia Garrity, Henlopen Avenue. I used to own an inn in Rhode Island. In Rhode Island, they had a major fire of a nightclub called The Station. 300 people killed because the owners did many things that violated code, and the inspector looked the other way. The lawsuits that came from all of these families hit the town, hit everyone in the building inspection department, and hit the state fire marshal's office. So don't take this, too lightly. All it would take is one of these rental houses going up in smoke with 6 kids in the basement and no means of egress for this town to be sued to the hilt especially if there's documentation that someone in the town employment saw an Airbnb listing that said the basement was suitable for children. So it is something that, I mean, it could bankrupt the town because the people coming here are connected and wealthy for the most part, and they will jump to a lawyer in a heartbeat if something happens to their kids. And even though I believe it's here, the state code says that occupancy doesn't include children under 12, they're just as dead as the adults in the house. So don't let that little loophole get in your way. But I urge you to make huge fines for any owner that has set up that kind of situation, and that there be no grandfathering whatsoever. Because grandfathering in a known hazard sets you up for a different kind of lawsuit. And personally, as a taxpayer, I don't want to pay for it. And, you know, what's going to tarnish the town's reputation as a tourist destination other than, yeah, we're burning up tourists right and left because the greedy owners want to shove people in the basements. So I just urge some caution on the issue and lots of legal advice.
Thank you. Carolyn?
Carolyn Diefendorfer, city resident. I just want to correct one thing. You do have to have a smoke detector in a basement. If you have equipment of any sort down there, you have to have a smoke detector. We have a smoke detector in our basement. Ours is used just for storage. It's only a partial basement. It's the picture they're using on WRDE related to all these stories. But there's also, I agree with the previous speaker. I don't think you can overlook this. If somebody illegally is using the basement, there has to be a way to stop it. Revoke their rental license. Subject them to periodic inspections that are unannounced. If you got a rental license, you have to have a local representative, I believe. You have to have a local representative. Make those inspections unannounced. It happened across the street from me, there was a house that tried to convert attic space. Similar issue, they had their rental license revoked for a period of time. They were subject to a $20,000 fine, and they were subject to periodic inspections in all of their rental properties in town. So make that happen. The other thing I would say is if you found any that were illegally converted after the fact, so that there's evidence there was construction done after the fact, make them produce their records and get the building permit fee from them for having done that. But you can't let this go on. All it takes is one fire. Thank you.
Thank you, Carolyn. Mike and then Susan, then Tom. Not you, Susan? Okay.
Mike Strange, Forest Oakley. I may be the only firefighter in my youth for about 14 years. And to your question, Mr. Preston, if you've ever fought a fire in a basement, it makes a gigantic difference if it's 10 foot high versus 6'6". I was almost killed in a small basement, and luckily 2 firefighters took me back out. But there's a bigger issue here, and the mayor may remember, going back several years ago with regard to attics, it's a similar situation where illegal conversion of attics were done. And the city took certain things to do so you wouldn't had to put a step down ladder as opposed to a walk up to prevent use of the attic that wasn't approved. And apparently one gentleman made it into a habitable space, was fined, and 2 years later, after he got his rental license back, they went right back doing the same thing. I think you can control the problem to a great degree. The reason that the basements were limited to 6'6" is because when it went greater than that, it was counted in the calculation for your floor area ratio for your building. And so you had to make it 6.6 to get around that, so if you wanted to have 3,000 feet above. The way that you can handle that is administratively, is that when, unfortunately, you can't stop people from doing stupid things and illegal things. But if, in fact, it is caught by the building and inspections It can be that your rental license is banned forever, period. That will get their attention. Or you can make the fine, and in this case, because there's a potential for death and you have all the documentation, you can justify $20, $30, or $40, or $50,000 fines. Or taking back all of the rental that they received for it. That is under your control administratively to try to stop this. What you can't do is stop selfish people from doing incredibly stupid things that put people at risk. And it's not just the children or the adults, it's the firefighters that go to the call. And you can help prevent that as well. Thank you.
Thank you, Mike. Tom?
Tom Gaynor, property owner in Rehoboth. To Commissioner Preston's point, how is it that every city in America has attics and basements and there's not a crisis? Have an honest discussion. What is it about? It's about controlling the density issues. Make the basements legal. Come up with an ingress egress. This phantom crisis of dead bodies. And I'm not disparaging the dead body issues, but it's a little disingenuous to be influencing a discussion in a resort town that is really trying to get to another point. The basement issue can be resolved in an instant. Make basements legal and make them compliant, like every other jurisdiction in America where there are basements. Make attics legal, make them compliant, like every other jurisdiction in the world that has attics. That's not really the issue that you're talking about, though. What you're talking about is controlling density, controlling rental bodies, controlling people's licenses, et cetera, et cetera, et cetera. Have an honest discussion. This is not an honest discussion. And this sensationalism of using, all of these tragedies that are absolutely tragedies have no applicability to the topic that is actually being discussed, which is restricting body counts in rental houses. So figure that out, have a discussion that's inclusive and comprehensive about the issue that you really want to talk about, not the phantom issue of dead children. That's disingenuous. And it's beneath the integrity of this board to use that kind of sensationalism for a FAR issue. Have the discussion about the FAR issue and map a way forward like every other city in the country does that has legal basements, that doesn't have tragedies daily.
Thank you, Tom. Anybody else? Harvey?
Harvey Shulman, Henlopen Avenue. Thank you, Mayor. First of all, thank you for your presentation. Three things. We do have FAR limits in town. So basements are part of the FAR question. So just like anything else, whether it's attics, whether it's a two-story, living room, you have to deal with the fact we have FAR. So if we didn't have FAR, and FAR is related to a lot of things, not just density. Secondly, good comment that was made, what do people do after a basement is constructed? Do they make changes? I don't know the answer to this, but maybe you need to figure out what's habitability, because to me it sounds like some of these basements didn't have bedrooms, but they had sleep sofas and other things. I mean, if you want to say that people shouldn't have furniture and other things in the basement, because then they're going to congregate down there and maybe be caught down there in the fire, address that. I just don't know what makes a basement habitable versus uninhabitable. I don't think it's just sleeping there. It's whether people go down there to spend time there other than for, dealing with their furnace and their water heater and other stuff. So I would suggest people can do construction and it might be perfectly fine and they don't change their construction, but they turn it into a space that can be used as habitability. And then I think the third thing I'd say is that basements are different than other FAR space, because we all know they're a hole in the ground, and that affects water and how water remains in the ground. It it affects runoff, it affects a lot of things. It affects trees, quite frankly. You know, you have a basement goes down. I mean, there's going to be limitations on what you can do with, owners can do with trees. So I would say, even from a perspective not of density, not of fire, but simply the effect on the environment, that basements are kind of a different thing, and they really need to be thought about a little differently. Egress, I agree with egress. The only thing I'd say on egress, Mayor, is if you're going to require more egress, which sounds like a great thing, you really should think about amending the zoning code as to what can be in the setback area, because the egress will probably have to be in some cases in the setback area, and right now you can't do that.
Thank you, Harvey. Anybody else? Last chance. Bringing it back to here. Again, we're going to need another session to do what we're deferring on tonight, and we can always bring this back at that time. Anybody else? Anything final word?
Mayor, or with the city manager, would you clarify, is our goal just to look at rental properties which may have modified basements subsequent to obtaining a rental license and prior to that, obtaining a certificate of occupancy? Like, what is our goal here, especially if the basement has an egress, like a window well, often 2 window wells?
Right. I do believe under our current code, the only way that we can regulate is through our rental license procedure. And under the building code, it does define different egress requirements depending on the height of the basement. So it just depends. But right now, that's all that we're able to do.
Right, and as you and I discussed, just because of small property sizes, this community, apart from some houses by the school, we don't have, walkout basements are not the norm here. So we're sort of handicapped, but I'm hopeful once we change the FAR and people who want a finished basement when building new construction, I hope we do better. That's at least, progress maybe. Thank you.
Thank you. Thanks, Amanda.
Thank you, Amanda.
Thank you.
With that, we'll move on to the next item of business, which is consider appointments to the, according to the agenda, Planning Commission, Board of Adjustment, Parks and Shade Tree Commission, Board of Elections, and Personnel Committee. With the Planning Commission, the terms up are John Dewey, Nan Hunter, and Mike Strange. I haven't talked with them yet, so I'm not nominating them tonight. But the good news perhaps is that until a reappointment made to them or a new appointment takes their seat, they can stay on indefinitely. So with that exception noted, Board of Adjustment, I'm nominating Barry Brandt to a 3-year term. He is, by the way, currently chair of the Board of Adjustment. Parks and Shade Tree Commission, nominating Carolyn Diefendorfer and Renee Simonton. They both serve currently. Board of Elections, Carl, is a little different here because they're supposed to have staggered terms, and over the years, they all ended up being the same, so I'm re-staggering them, if you will. Carl Pierce is nominated for a 3-year term ending in 2027. He is an alternate member of the Board of Elections. Ned Kesmodal nominating for a 2-year term ending in 2026. Steve Curson, 1 year ending in 2025. They all have experience and are members currently. Then for the Personnel Committee, I'm nominating Commissioner Ed Chernowski as chair. And the 2 members, colleagues with Ed, are Commissioner Don Preston and Commissioner Craig Thier. So I would entertain a motion to appoint the slate as noted.
Mayor, I just have a question, if I may.
Yeah.
Your comment on the Planning Commission, you said you're not reappointing at this time because you haven't talked to them, is that correct?
Yeah, I want to talk to them, and I really haven't made my mind up on whether I'm going to reappoint all three at the same time or not.
Mayor, I would move approval of the slate of nominations that you just read.
Have a second?
Second.
I have a motion by Commissioner Ed Chanowski and a second by Commissioner Suzanne Good to appoint the slate as read. Is there any further discussion? If not, all those in favor signify by saying aye. Do I have to? No, we're not going to take comments today. That's all right. Is there any further discussion? If not, all those in favor signify by saying aye. Aye. Those opposed? And the motion is carried. Thank you very much. With that, next item of business is discuss and consider awarding a contract for City Hall cleaning services to Oceanside Cleaning, Inc. in the amount of $128,544.
Good evening, Mr. Mayor and Commissioners. So recently, the city's contract for our cleaning services of City Hall expired. So city staff went out for bid on this. It was advertised in the Cape Gazette from August 20th through September 20th. And we had multiple parties that bid on this contract. Our current company that we utilize is ServPro. They came in with a bid for a yearly price of $264,000. Anytime Cleaners came in with a varying price, which ranges from $10,800 to $11,600 a month. And Oceanside Cleaning was our low bidder with a yearly price of $128,544. All three bidders were qualified bidders. We did check the references of Oceanside Cleaning, and they were all favorable. So city staff is recommending awarding the 2-year contract to Oceanside Cleaning in the amount of $128,544. And I'm here for any questions that you may have.
Any questions up here?
If I may, is this contract cleaning just the administrative building, or what services, what buildings does this cover?
So this is for the City Hall complex. So it does include the police department, all of these areas, yes.
Not the convention center.
It includes the convention center, but not for events. So we do have staff that take care of the events.
You may have mentioned this, so I apologize.
Craig?
Sorry, Mayor. 2 questions, and you may have covered these, so I apologize. From a budget perspective, in line of with what you were expecting to spend?
Yeah, so there is $155,000 budgeted in this line item for this. And currently, if we stayed with ServPro, this is $133,000 less a year. So we are pleased with this bid.
Okay. And ServPro is the current one?
Correct.
Any thoughts on why they came in? I mean, you know, they're basically double. Any thoughts on why they came in double the Oceanside Cleaning?
No. It's the same specifications that we put in the bid document.
Okay.
Yeah.
Thank you.
If there's further discussion, I would entertain a motion.
Mayor, I'd make a motion to award the 2-year contract for City Hall cleaning services to Oceanside Cleaning Incorporated in the amount of $128,544 per year. Second.
I have a motion by Commissioner Patrick Gossett and a second by Commissioner Don Preston to award 2-year contract City Hall cleaning services to Oceanside Cleaning, Inc. in the amount of $128,544 per year. Is there any additional discussion? If not, we'll do, all those in favor signify by saying aye. Aye.
Aye.
Those opposed? And the motion carries. Thank you very much, Taylor. With that, we'll go to commissioner announcements and comments. Does anybody have anything brief in this category? If not, then.
Mayor, I'm sorry, Mayor,
Yep.
just a question. Could you just review what outstanding agenda items will be either transferred to the workshop or the next meeting, or is there, if you could update us on the schedule of when that would be managed?
Items, old business 14D, which has to do with definitions of basements, et cetera. And then item old business 14E, which would be consider a resolution setting a public hearing in the matter of basements. So obviously, I don't know if they could be combined or not, but obviously we'd want to be satisfied with the one before we adopt a resolution going forward.
If I may make a request also, if those are the two coming back, depending on when they're scheduled, if we could also have the code enforcement officers come back during that discussion, the presentation that was done today, just from background information, if
Oh,
we may.
yeah, absolutely, absolutely.
Thank you.
Thank you. 15C. Did I skip it? That was discussed. That was discussed in part during the hearing. That's what got me confused. So that's now behind us.
There's two different items on the agenda. One was the definitions in the zoning code, and one is the ordinance.
Yeah, no, Lisa, 15C was added to number 13, the public hearing. So those are both together. I announced that at the beginning before I left the room, so you must not have heard it. Correct? With that,
Mayor, one quick request.
Yes, ma'am.
To all of my colleagues that I think there's a major decision ahead of the city. The deadline has sort of been imposed upon us by the county that may or may not be what we should accept. But I'm hoping there's some consideration in the next 2 months to hold a town hall, because a lot of the citizens are unaware of what's coming down the line in terms of Rehoboth Beach becoming the waste repository for areas as far north and west as Nassau Vineyards off Route 404. So I think
Suzanne, respectfully, you're trying to commandeer a topic that's already scheduled for the agenda. We've got a November workshop, which I know you're not going to be here, where we have engineers coming, that's a consultant, and we have a path forward. So I hear you, I respect what you say, but we already have a path forward in that.
it was just to sort of ask the public to get involved. Thank you.
All right, thank you.
Mayor, just to follow up on
Commissioner.
that, I, notwithstanding your comments back to her, it's an interesting point that she raises about town hall meetings. Do we do those?
On occasion, yes.
Does anybody recall, maybe Evan? Evan, do you recall the last time we did one? I mean, I'm sorry, Taylor, I'm not asking you because you're so new, but.
Sure. So in my experience, we have done town halls. That's like a formal public engagement workshop, which is advertised. Usually it's held, in my experience, it was for the Lakes Management Plan that was developed by the Corps. I think we held it in the convention center. We also did a town hall for the Wilmington-Baltimore Avenue Streetscape Concept, which was held in the convention center. So yeah, usually in my experience, town halls, it's open to the public. They can come in for a certain period of time. Usually done during the day. and again, held in the convention center to accommodate, so.
Thank you for that. Thank you, Suzanne, for
Mayor,
the
may I
comment.
add that July 2019, I believe, was a standing room only crowd for a town hall focused on water and wastewater rates. So do you know whether there's
So
been
I
any
think
of
we
those
may be
others?
confusing two things. So we have commissioner meetings, which will be advertised as public meetings, and that's where we have, depending on the topic, we can have a large attendance from the public. I've been here where we've had meetings that not only occupy this room, but occupy the caucus room and occupy the third floor training room. But not to be confused with town hall meetings where the commissioners are not necessarily expected to be there in a quorum. They may stop in just to talk with folks or talk with the city staff. So I think the two are a little bit separate from that respect.
I think I support the idea that a town hall meeting on something of this magnitude makes a lot of sense to me, just as a way to disseminate very important information to the public. And again, not us necessarily being the presenters or in a quorum or whatever, but there's a lot of details here associated with this that we might not get. I mean, look how many people show up even on an important day. It's not that many, but I think if people really understood what decision is in front of us, they would probably want to show up for something like this. Just a thought. Thank you, Suzanne. I think it's a great idea.
Future meeting dates, Monday, November 4th is a workshop meeting, and we get the citizen comments. Anybody would like a 3-minute limit to, this is for off-topic. This is for off-topic content.
Okay, Lisa Schlosser, 14 Dover. I appreciate the courage of the 3 commissioners that took on the old and antiquated ways of the, well, now it's 4 old guard commissioners that voted for this ordinance. I'm really sad that you now brought in another person to be part of your old guard. And just to be clear, a couple weeks ago, Mayor Mills, you basically said that this ordinance that you guys reiterated today is passed. It was incomprehensible, was a terrible ordinance. And many of you said that you didn't even know that it covered camping trailers and other trailers, but yet you voted for it. So just to be clear exactly how not insightful this ordinance is, look here. Look, can you guys see that? Put your glasses on if you can't. Okay? This is what is not covered under the current ordinance. I can park this motorhome 40 feet with slide outs to my neighbors on my driveway for 180 days, or at least 22 feet. This little 15-foot trailer is what is not allowed on private property now. You guys didn't even think this through, and it's a terrible piece of an ordinance, and you should readdress it to be fair to the residents of this town who are impacted. For those in the audience, a motorhome such as this, maybe it's a little more than 22 feet, but that's allowed with side outs. It is. This little trailer here, 15 feet, not allowed. And guess how many of these little 15-foot ones we have in town? 1, mine. You passed a bad ordinance. I hope you change your ways, and I hope the new commissioner who voted with the folks that, well, Stan, you voted against it, but who voted with the people that have continually voted with this, think about the way you do business, think about planning better, thinking about putting in place good ordinances and not crappy ordinances. Some of you are not even looking. Commissioner Gossett, did you see it? I wasn't sure if you did. Okay, all right, good, because I think I'm going to buy one of these, just so you know. So, and I'm going to park it right smack dab in my private driveway for 180 days. Then I'm going to drive it onto the street for 48 hours, and then I'm going to put it back in my private driveway. That's my plan, at least. So thanks for listening, and you're all invited to come have happy hour in my new motorhome that's going to be parked in my private driveway.
Thank you,
But
Lee.
the point is, since I have 9 seconds, please, please, please don't pass ordinances in 11 days when your residents, the people that voted for you, aren't even in town.
Thank you, Lisa.
Thank you. And thanks to the commissioners that have
Tom?
moral courage.
I second what she said. Tom Gaynor, property owner. It was sloppy, it was awful, and you guys should have repealed it. And I wish you had stuck to your guns like you did last time and fought for a repeal of it instead of just going along with the prevailing winds. But the other thing is that I wanted to ask you about in the Board of Elections. I don't remember who was running the room in the convention center when, I don't know if you remember, that I got quite angry because there was some incompetent person managing the room. And the paper tickets that were pulled out of the ballot machines, first off, one of them was shut down early with no notice to the candidates. Secondly, the paper records were pulled out of the machine and then stuck on a private employee's person in their pocket with no oversight and no second babysitter for a chain of custody issue and a chain of custody record with regard to the sanctity of that written printed record. So whoever was running the room in the convention center, who then got visibly aggressive and antagonistic with me when it was pointed out to them that their process was completely antithetical to the maintenance of a republic. It happened on the second machine after the close of time at 6 o'clock. And finally, by the third machine at 6:15, after I was getting so angry to the point of almost being thrown out of the room, I tend to do that when I feel righteous about something. They finally changed the process. And then whoever the idiot was who was managing the room and should have been managing the electoral process and the sanctity of the chain of custody of the ticket came up to me and said, well, what would you have suggested? I said, well, first off, you should have asked me that before you threatened to throw me out of the room when I asked
I'm
the issue.
practicing for next time you
Good.
say idiot.
So
we don't need to go there.
Well,
right?
you also talked about, Commissioner Good commandeering a process. So, pay attention to your own exhortations. The issue that was at stake is the sanctity of our vote. And if somebody doesn't understand basic procedural issues on the sanctity of chain of custody of that ticket and the preservation of data and having redundancies of people backing that up and people watching employees stick that ticket in their personal clothing and their pockets, they shouldn't be reappointed to the Board of Elections. So I don't know who that person was. I don't know if you know who that person was that I was having the argument with, who was pretty obnoxious, but exhort whoever is going to be running the Board of Elections from here out to have some legitimate processes for the maintenance of the integrity of the election and some redundancies on the preservation of the chain of custody of those pieces of paper. And for God's sake, they should not be putting them on their person next to an open briefcase, next to the ballot machine, and then putting them in their personal pocket as they walk around.
Thank you,
So,
Tom.
thank you.
Anybody else? That closes citizen comment. The next item is an executive session for the purpose of preliminary discussions on sales or leases of real property as permitted by 29 Del C, Section 10,004B2 of the Freedom of Information Act. This is intended for us to go into executive session, and I would entertain a motion. And if you, in the motion, read the entirety of the agenda line there.
So moved. No,
You have to read the whole thing.
Mayor, I
Executive
move
session,
we
okay.
go into executive session for the purpose of preliminary discussions on sales or leases of real property as permitted by 29 Del C 10,004B2.
Or a second?
Second.
We have a motion by Commissioner Ed Chernowski and a second by Commissioner Don Preston to enter into executive session for the purpose of preliminary discussions on sales or leases of real property as noted in the agenda. Is there any discussion? All those in favor signify by saying aye. Aye. Those opposed? And so we are now entering into, we will be entering into executive session. To the members of the public, the duration of the executive session is unknown. There will be no actions or votes taken in executive session. We will come back into public session to take additional citizen comment. and adjourn, and when we are back in public session, no actions will be turned. So in other words, you don't have to hang around. With that, we are recessed into executive session. Check out in the hall, Ed.
I did. You did.
You ready? I'd like to entertain a motion to come out of executive session back into public session.
So moved.
Second.
We have a motion by Commissioner Chernowski and a second by Commissioner Preston to come out of executive session back into public session. Is there any discussion? If not, I'll call the question. All those in favor coming back into public session signify by saying aye.
Aye.
Aye. Those opposed, and we are now back into public session. As there are no members of the public here, therefore I can skip over an additional public comment period. And instead, since there's no action to be taken.
Sorry, just a comment that the hallway was checked and no one was present.
Correct.
Yes, correct. And with that, no further business. I adjourn this meeting at 7:04 PM. Thank you very much.